The Strawman illusion. Thomas Anderson. The book that the governments, banks and corporations do not want you to see. Classified. The Strawman illusion. Thomas Anderson. The Strawman illusion. Thomas Anderson. The book that the governments, banks and corporations do not want you to see. Classified. The Strawman illusion. Thomas Anderson. The book that the governments, banks and corporations do not want you to see. Classified. The book that the governments, banks and corporations do not want you to see. Thomas Anderson. Book 1. Quote from The Matrix. Morpheus: I imagine that right now you're feeling a bit like Alice, tumbling down the rabbit hole. Neo: you could say that, Morpheus. I can see it in your eyes. You have the look of a man who accepts what he sees, because he is expecting to wake up. Ironically, this is not far from the truth. Do you believe in fate, Neo? Neo: no. Morpheus: why not? Neo: because I don't like the idea that I'm not in control of my life. Morpheus: I know exactly what you mean. Let me tell you why you're here. You're here because you know something. What you know, you can't explain, but you feel it. You felt it your entire life. That there's something wrong with the world. You don't know what it is, but it's there, like a splinter in your mind, driving you mad. It is this feeling that has brought you to me. Do you know what I'm talking about? Neo: the Matrix. Morpheus: do you want to know what it is? The Matrix is everywhere. It is all around us. Even now in this very room. You can see it when you look out your window, or when you turn on your television. You can feel it when you go to work, when you go to church, when you pay your taxes. It is the world that has been pulled over your eyes to blind you from the truth. Neo: what truth? Morpheus: that you are a slave. Neo: like everyone else, you were born into bondage. Born into a prison that you cannot smell or taste or touch. A prison for your mind. Unfortunately, no one can be told what the Matrix is. You have to see it for yourself. This is your last chance. After this, there is no turning back. You take the blue pill, the story ends. You wake up in your bed and believe whatever you want to believe. You take the red pill, and you stay in Wonderland, and I show you how deep the rabbit hole goes. Remember, all I'm offering is the truth, nothing more. Index page. Quote from The Matrix 2. Index 3. Author's note 4. Introduction 5. The Strawman illusion. 5. All aboard the citizenship. 7. The digital machine world. 10. Vessels. 11. Trademarks. 12. Choice. 14. Private versus public. 15. Prisoners and bonded warehouses. 15. WHORU. Exposing the fiction. 16. Fines, courts and presentments. 18. Undertaking as to bail notice. 19. Notice of conditional acceptance. 21. Affidavit to court. 22. Accepted for value stamp. 23. Jurisdiction. 24. Transport. 25. Money and debt verification. 30. Registered post. 35. The redraft. 36. Discharge loan statement. 37. Credit reporting agencies. 39. The process step by step. 40. Birth certificate. 55. Queen, Crown and Commonwealth. 56. Citizenship and marriage licenses. 61. Certificate example. 62. The death of the Strawman. 65. Page 3. Identification. 65. Taxation and the auto. 66. Understanding primary liability. 71. Fines and infringement notices. 74. The coming global monetary collapse. Survival tips. 75. Suggested reading. 76. Documentary list. 76. No trespass could notice. 77. Crown Land Company certificate. 77. And note. 78. Author's note. Firstly, I am not a lawyer, pronounced liar, or a legal practitioner, so I cannot offer you any legal advice. I am a researcher and seeker of the truth, and what I offer you here is the result of much time and effort to uncover the secrets of the hidden world. Any and all information, documents, templates and research contained within this book is intended for educational purposes. It is at your sole discretion what you do with it, and I bear no responsibility or liability for the use or misuse of it. Reprinting, copying and distribution for monetary gain is not permitted. However, please feel free to share the information with family and friends who you think may find it of interest. $100 may seem like a lot of money to pay for this book, but you will soon discover the truth of the matter, and just how valuable it is. I thought that the equivalent of 2 hours of my time, besides the $20 that it costs to print, bind and post each copy, was a reasonable request as a donation or gift, considering the following. This book is the result of 6 years research and study of a vast amount of information as well as practical experimentation and real-life use of the documents contained within. Trying to condense thousands of pages of info into just 100 pages has proven to be a challenge in itself. I have spent no less than 4 hours every day, including weekends for the past 6 years to be able to bring you this compact, edited version of all that research. I have sacrificed my personal time and family time by doing so and at times placed myself at great risk. That amounts to approximately 8,760 hours work, which if I charged at my normal rate of $40 per hour, this book would be valued at $350,400. I didn't think you would be willing to pay that much, so I'm just asking for 2 of those hours. Fair? Please also take a moment to give thanks to all the other pioneers out there. People like Mary C., Victoria J., Winston, Mark P., David M., Rob M., Alex J., Arthur, Adam, Bulletproof Monk and so on, doing their best to uncover the truth for you. Thank you. Thomas Anderson, Trademark Legal Fiction, page 4. Introduction to Seek Safety. One must go to the heart of danger. Timac as Bruce Leroy Barry Gordy's The Last Dragon. I encourage all of you to awaken from your daydream. You have been deceived into believing that what you have been taught about the world so far is true. I assure you it is not. After reading this book you may become disillusioned, angry, frustrated and feel cheated, as it will challenge all that you know, and all that you currently believe. May I suggest that you take this newfound knowledge and think of it as the key to a door that has suddenly opened, through which you may walk if you so desire, an exit or entry, however you perceive it, to allow you to see the world from a different perspective. Until now, you may have only been looking at the world from the inside, but this book will allow you to view the world from the outside, looking in, where you will see the manipulation that before was invisible to you. This book is not for those without compassion, morals, and respect for all living things. It is an empowering tool to help you walk the path of a free man or woman and prepare you for the great responsibility that comes with it. Welcome to the real world. The Strawman illusion. To explain in very simple terms the notion of the Strawman, it is a front, a facade, a persona, which is where the word person actually comes from. A person is a legal entity, created by the government from your birth registration certificate, and acts as a transmitting utility or agent in commerce for you to do business with, or interface with the world, which is run by other fictional entities. All statute laws and acts apply only to persons. Please read that statement again. A homeowner is an artificial person, all capitals, name on the land title deed, who must pay the government land taxes every year, or else the home will be taken away from the living being who thinks he owns the home, in violation of the living being's fundamental rights of life, liberty and property, because he never owned the property in the first place. The living being has equitable title while the government has legal title. Other examples of artificial persons, legal entities, are voter, teacher, landlord, tenant, taxpayer, director, shareholder, cardholder, for credit cards, officer, employer, employee, and so on. One only has to look at the corporation's law to see the truth. Let's have a quick look at some of the meanings of the word person, for all of those who are new to the subject. Person, noun. 1. An individual human being. 2. A human being or corporation recognized in law as having certain rights and obligations. Person, in the sense of an individual human being. People, persons, a human being, natural person, or a corporation, artificial person, regarded as having rights and duties under the law. Page 5. Chambers Dictionary 9th edition. Person, 1. An individual human being. 2. A human being or a corporation recognized in law as having certain rights and obligations. Collins Australian Dictionary 5th edition section 17 Levy of income tax 17.1 levied on taxable incomes of certain persons subject to this act. Income tax at the rates declared by the Parliament is levied, and shall be paid, for the financial year that commenced on July 1, 1965 and for each succeeding financial year, upon the taxable income derived during the year of income by any person, whether a resident or a non-resident. H. The term person includes an individual, a company and any other body of persons. Tax, a charge, especially a pecuniary burden which is imposed by authority. Specifically, a charge or burden laid upon persons on property for the support of a government. The Strawman's primary function is as a creation of the state and a means to extract your energy and labor during your life on this earth to keep their fiction alive. The fiction is really just a parasite, which lives off of us. It is only there because we allowed it to be there. Some will argue that taxes and the government build the roads and infrastructure, but you can clearly see when you look around that it is we the people that do all the work. Because the living cannot speak to the dead, the government needs a medium, hence the person is created and we ignorantly agree to become the surety for it. The process is known as an enjointer, a term that you will become more familiar with throughout this book, as it is the way that all of you become liable for tax, fines, obligations, payments and so on. It means to join with, to become one instead of remaining separate from your person. This happens in court when you appear as the defendant. The defendant is in reality the person. Strawman all caps fiction listed on the presentment or court order that looks and sounds like your real name. Once you become the defendant, the court will treat you as such, and your common law rights will have vanished, as you are now a person. Here is a section from a court transcript of someone who didn't know what he was doing. So the defendant comes before the court as a defendant as defined in the Criminal Procedure Act 1986. The defendant appears to be looking at dictionary definitions to suit his purpose. He also indicated that he challenges the court attendance notice, using the phrase, natural person. He said that describes a mask that is lifelike or concerned with physical things. He then goes further on to say he is a man that God created. I am a man who is free, that is, not a slave nor servant, having right and social and political liberty. A man is alive in God's glory. Then quoting verses from the Bible as well as the Magna Carta and the Imperial Acts Application Act and also United Kingdom legislation in relation to. The rest of the affidavit appears to talk about other sections of the Act where he is suggesting he is not a defendant. Page 6. I am satisfied. In fact, he is a defendant and I am also satisfied that the court attendance notice was adequately served and the four alleged offenses are adequate and that proper particulars have been established in the court attendance notice to those matters. All aboard the citizenship. What you didn't know, and were never taught until now, is that you are in reality a sovereign being, a freeborn man or woman, with natural inalienable rights. These rights include being able to travel freely on the common ways of the land without license or registration, authorization or permission. However, you were instead born into bondage and slavery, unknown to you by invisible contracts that I will explain and go into more detail later on in this book. From this time forward, under God, I pledge my loyalty to Australia and its people, whose democratic beliefs I share, whose rights and liberties I respect, and whose laws I will uphold and obey. Pledge of commitment as a citizen of the Commonwealth of Australia. It has been said that we are all lost in the sea of Admiralty jurisdiction. What this really means is maritime law. Most laws originated from England or Rome at one time or another, and as such are copyright of the Crown, as this example shows, in the fine print at the bottom of an accident claim form. Once you travel beyond the landmass of England and across the seas, you are operating under Admiralty law, which is very different from common law, also known as the law of the land. All of the rules, regulations, acts, and legal terminology that surround us and pervade every aspect of our social lives are state, statute, law, and essentially based on piracy, as represented by the Jolly Roger, or skull and crossbones. So many words and phrases that have become common use have dual meanings such as navel, navel, birth, birth, soul, soul, semen, semen, and so on. It is all part of what the governments and corporations refer to as their policy. Make no mistake, they are all essentially just private companies, out for commercial gain by the enslavement of the population as its property or stock. Page 7. The following extract from the U.S. Securities and Exchange Commission website search shows clearly that the Commonwealth of Australia that you may have pledged to obey the laws of is a company, not a country or place. Fortunately, I was able to also obtain a copy of the entry below and many others from a fellow researcher, as they have since been removed or hidden from public view on the ASIC site. Does this black ink on a piece of paper look like a country or place? Do you think that it's able to do anything by itself? Page 8. Each of the states, territories, courts, police, schools and hospitals are all companies. Even the Queen is a company. Here are some more examples. The government and crown policy enforcers, police, are essentially pirates, always on the lookout for revenue, for lack of gold, and will try to board your vessel whenever they can for monetary gain, pillage and plunder. Sure, there might be some honest cops out there, and we do need them in their correct capacity as peacekeepers and public servants to keep us safe from the real criminals. However, this is not what most of them do. The agents follow the policy as if it were the words of a living being, and when we refer to the government, we imagine it as a real thing simply because of the agents. It has no life of its own, no more than the words on this piece of paper. Page 9. The digital machine world. This is a man-made digital system, which is based upon the natural analog world, yet it is fictional in substance, as all entities are dead. We refer to them as being dead, because they are not real. They have no power of their own. They are not living things and only exist on paper. This includes governments, corporations, companies, banks, police, hospitals and schools. Digital cannot and does not interface with analog without some sort of medium. Digital is the realm of the machine world. Ones and zeros, on and off, harsh, sharp square wave frequencies with no harmonics and no ambience, because it does not emanate from a natural source. Analog is sine wave, flowing, rhythmic, harmonic, energizing frequencies. This is why MP3s and other digital technology is being pushed, to keep us attuned and out of sync with the natural world. Avoid it at all costs as it disrupts natural living systems and confines your reality. Can you see how much wonderful sound you are missing out on by listening to MP3s which cut off the natural wave into steps? Have you ever seen ripples on a lake forming square wave formations? I didn't think so. This is the same process as the fictional corporate paper world. A person appears to be the same thing as a living being, or spirit, soul living in a human form, but it is not. It's just an illusion. The only way that a legal fiction or entity can operate, move, have any power or physically do anything, is through a medium, an agent. Every company has a policy. Policy is not law. McDonald's has a policy. However, you don't often see Ronald McDonald asking you for ID or coming over to your house and telling you what to do. That's because you're probably not an employee of McDonald's, and so are not bound by their policy. However, you are considered the property of an employee, slave, of the government by your own admission and consent. Here is an email conversation with NSW Government Minister Prudence Goward giving her opinion if there is any difference between one company and another company. Dear Ms. Goward, I wonder if you would be so kind as to advise me on a question I have about companies. Page 10. Is there any essential basic difference between one company and another company? For example, does one company have any more or less rights or privileges than another? And moreover, can a company compel someone, who is not an employee of that company, to follow its policy? Best wishes, Thomas Anderson. Dear Mr. Anderson, these questions are about contractual relationships. If the company is selling someone, not an employee, a service or good, then they may demand that a policy be followed before the good or service is provided. Companies as such do not have different rights. What they do have is different contractual obligations, which are supposed to be willingly entered into. If you gave me an example, I might be able to help more. Prue then sent her this reply with the above basic documents, and not surprisingly, never heard from her again. Dear M. Scobert, thank you for taking the time to reply. I recently discovered that all the government departments and states are essentially legal entities or companies, see attached, and wondered what the difference was between them and other companies, such as McDonald's or Kohl's, Meyer, etc. It seems that in order for a company to enforce its policy upon people, they would need to be an employee, or as you suggest, otherwise contractually obligated. Best wishes, Thomas Anderson and B. They do this through the corporatization of our vessel, or a person, the all-capital letter legal fiction, known as the Strawman. Vessels. The idea of a vessel being a carrier or container for something else is a common term that is used in admiralty, and there are many examples aside from the obvious description of a boat or ship upon the sea. Your body is also such a vessel, a container for your spirit or soul, the life force that animates the flesh and blood. It also contains other vessels that your blood travels through, much in the same way the highways carry the life force of the commercial world. It is the machine world emulating the natural analog world. Life has three main constituents: water, salt and electricity, vibration or energy, plus intention. The digital world mimics this, using terms such as charge, discharge, circuit cord, etc. It all has to do with the outflowing of your energy to animate the dead. The next time you see an ambulance racing to save someone, stop to consider that the patient listed on the chart is the person, in all caps. This might give you a clue as to why the government provides all these services such as Medicare and public hospitals, not for your benefit, but to look after its property. Why do you think it's an offense not to wear a seatbelt or helmet? Because as the surety, you are putting their property at risk of injury or death, meaning the possible closure of the account, and loss of stock. Let's consider now the comparison between shipping and childbirth. Page 11. Take for instance a pregnant woman, who is laden with her cargo. She arrives at the dock, ward, where the vessel is to be unloaded. During delivery of the cargo, the item travels down the birth canal, it is received, the tether, cord, is cut and the cargo is received and registered with the port authority and given a consignment number. This is where the problem begins, as the unsuspecting parents who probably married the state in the first place and their newborn child are now enjoined with the government as its property or collateral value. Furthermore, the government will offer attractive free benefits and bonuses such as a baby bonus of $5,000 which parents gladly accept. This is merely the government purchasing a security interest in the child and its person. The birth certificate is the moment the Strawman is first created. Remember the Wizard of Oz, the Scarecrow, Strawman, had no brain. The creators of that film as well as the writer of Alice in Wonderland obviously knew about this information, and that is also one of the reasons those two films are quoted so much in the movie The Matrix. The Matrix cleverly explains what is really going on in the disguise of entertainment. Take out all your credit cards, utility bills and any other official document, and you'll see exactly who you are right now. Most of you had no idea when you signed that contract, or the license, or the back of your Visa card that you were enjoining with the Strawman all-capital letter fiction, becoming one with it. Notice the all-capitalization of the cardholder's name, which is the fiction Strawman person, and its assigned account number. Remember, there is no money, so only your signature can create the value. To facilitate the payment of this account directly from Medicare, we require your signature to assign the benefit to ClinPath. Please complete the following sections on the reverse side of this letter. 1. Sign in the box indicated by the words patient signature and date, and 2. Check the Medicare number, located at the top of the form, against your current card and amend if necessary. Page 12. If you or a responsible person, immediate relative, are unable to sign, please indicate this by the words "unable to sign" instead of a patient's signature. Your assistance in returning this completed documentation is greatly appreciated. It will avoid the burden of receiving an account that would require lodgement with Medicare and subsequent return of the benefit check to Cantey. It is even possible to register your person with a trademark office, and then you will fully comprehend the separation between you and it. Of course, many people have the same name, so what sets one Strawman apart from another is the creation date, which obviously coincides with your birth date, plus your birth certificate, registration number, and any subsequent reference numbers assigned to the person, such as a tax file number or social security number. Page 13. The Strawman in its digital all-caps world creates a paper trail which exists as the proof of ownership or grant of security interest in the stock. Choice. Most people like to think they are free to do as they please in their daily lives, but in reality it is much the same as a mouse running around within the confines of a maze, thinking it has a choice which direction to take. This apparent choice of direction or imaginary freedom is what keeps us from questioning the reality of the situation. There are really only four main choices you have in any given situation, which are: 1. Silence, dishonor, as in you have the right to remain silent. Silence is also considered tacit agreement, as you obviously have no objection or rebuttal. 2. Argument, dishonor. This is the single most common cause of all problems today, and the reason that courts and lawyers make so much money. Unless there is a controversy, or you give the court energy to move, it cannot step in, assume jurisdiction and tell you what to do. 3. Full acceptance, honor. You accept full responsibility for your actions and will bear the consequence. Although honorable, it can be a dangerous place to do when it comes to the law and its acts. 4. Conditional acceptance, honor, aka A4V. This is one of the methods I use all the time to rebut presumptions, stay within honor, in the legal sense, and remain out of the controversy, and out of court. For example, if I came up to you and said, "Hey, that's a nice red shirt you have on, but it was really green," and you say, "But it's not red, it's green ... Suddenly you've created a controversy. The correct way is to rebut the presumption by saying, "Oh, do you see it that way?" I will be teaching you more about this powerful method. As applied correctly, it will keep you out of trouble, and if followed properly when you are writing replies to lawyers, solicitors, debt collectors, or government agencies, you are not giving away any of your commercial energy, allowing them to move. You have not enjoined and therefore will not become the defendant. The only way that a magistrate or judge can assume jurisdiction over you in court is to try to get you to do something he or she tells you to do. That might be answering a question, standing, or giving your name. A quick look at the four options above will tell you immediately where you stand, and what the consequences are if you answer incorrectly, or if you do what you are told. The assumption being is that if you automatically do what someone tells you to do, they have control over you. In a court of law, this is deadly. Of course, you cannot dishonor the court, contempt, by not answering, being silent, or arguing, so you must always rebut the presumption. We'll go into that in detail a bit later on with some real-life court situations and things to say if you are ever invited into Wonderland. You may have already encountered silence from a government agency or other agency when it comes to asking them questions that they don't want to tell you the answer to. It's their way of telling you that you're correct in what you're saying, without giving themselves liability which could be used to demonstrate an admission of guilt or fraud. Page 14. Private versus public. There is a hidden line between the private and public. Most people assume that they are the public, and that public property is theirs to use. Take for example public transport or a public park. Public is the realm of the person. A public servant is a servant of the system and the regulator of the persons or entities within it. It has nothing to do with the private world, which is where we want to exist, outside of the matrix, in the real world. An effective way to keep unwanted persons or entities out of your personal private property is with the no trespass notice. If there is no such notice outside your home, then the assumption is that it is an open house, with no objection to visitors. In the back of the book I have included a no trespass notice that you can display at the entry to your home to keep unwanted visitors out. You have a right to protect your private property, and that includes your house, your car, your family and your body. Policy enforcers will often try to locate your physical body and arrest it as the surety for the person, debtor, so it's always good to correct and educate them when asked if you are the person on the presentment by saying, "I'm sorry, you must have the wrong person." Sometimes the fictional entities known as governments and companies will leave clues right out in the open for us that we don't see. Clues, which reveal the hidden meaning behind supposedly innocent words. Take for example the terminology used when someone becomes disabled or an invalid pensioner. Invalid means no longer valid. They are telling us that they are no longer of any use as an instrument to create value. Instead, they become a ward of the state, dependent upon the system for survival. Disabled means no longer able to perform to full capacity. The same can be said of people on the dole. All those enjoying with their persons and getting paid by the government and wondering why the money is so low. It is merely to keep people alive enough to extract whatever value they have as collateral, while at the same time buying a security interest in the person and keeping them poor, undereducated, undernourished and underdeveloped. It creates an easy-to-control, predictable lower class of dependents whose daily lives are primarily concerned with consumerism, distraction and breeding. This is further supported by pharmaceutical and drug addiction, sport, alcohol and other types of escapism from the depression of never having enough. Prisoners and bonded warehouses. When a person is convicted of an offense, the surety for the defendant, your body, is taken along to a bonded warehouse, prison, and there it sits until the bond matures. Release date. Page 15. A bond is issued for each prisoner and assigned a CUSIP number, which is an identifying number that allows stock to be tracked on the stock market. This number is pooled with the rest of the numbers and traded under the name of the institution or company on the market as a securities exchange. Again, this is one of the primary reasons you do not want to be the surety for the Strawman. WHO are you? So you're probably wondering, if you're not the person listed on your credit cards, loans, mortgage or utility bills, who the hell am I? To accurately describe yourself, you could say you are the living life force within a man or woman, or the embodiment of a spiritual soul that animates the flesh, and as such you are the principal creditor for the Strawman, debtor. It's a very powerful position to be the principal creditor, as it means that you are in the highest position of authority. While I was learning this process, in the early days I created a separation between myself and the fiction by always signing as the authorized agent for it. This worked very well, however later I found out that an agent and the principal cannot be one and the same, so it made better sense to be the one with highest rank. By the way, Mr. is the lowest rank in Admiralty, sovereign being the highest, so that should tell you why those letters often preface the person, and why a male child, before they have signed any contracts, is called a master. Exposing the fiction. So now that you comprehend what the fiction is, let's take a look at some of them, and see them for what they really are. Obviously, if you are a public servant, citizen, resident, or otherwise considered an employee of the company known as the Commonwealth of Australia, then you must follow its policy. It is these invisible contracts such as boarding the citizenship that we become enslaved by our own application and consent. Here are some strange and disturbing sections of the Police Powers Act 2000. 288 Approval for creation of birth certificate for assumed identity. 1. The chief executive officer of a law enforcement agency may apply to the independent member for authority to create a birth certificate. A birth certificate approval for an assumed identity for an authorized person. 40 person may be required to state name and address. 1. A police officer may require a person to state the person's correct name and address in prescribed circumstances. 2. Also, the police officer may require the person to give evidence of the correctness of the stated name and address if, in the circumstances, it would be reasonable to expect the person to be in possession of evidence of the correctness of the stated name or address, or to otherwise be able to give the evidence. 3. A person does not commit an offense against Section 791 if the person was required by a police officer to state the person's name and address and the person is not proved. S4165 S41 Police Powers and Responsibilities Act 2000 page 16. A. For Section 41A or B. To have committed the offense, or B. For Section 41F to be the person named in the warrant, summons, order or court document, or A. For Section 41H to have been involved or to be about to be involved in an act of domestic violence or associated domestic violence, or D. For Section 41I or J. To have been able to help in the investigation. 476 Commissioner may authorize police officers to take DNA samples. 1. The Commissioner may authorize a police officer to take DNA samples. However, the Commissioner may authorize a police officer only if the Commissioner is satisfied the police officer A. has the necessary experience or expertise to be able to take the samples, or B. has satisfactorily completed a course of training approved by the Commissioner for the purpose. 477 Where DNA sample may be taken. A DNA sampler may take a DNA sample from a person at a location in any of the following places that provide reasonable privacy for the person. A. A police station or police establishment. B. A hospital. A. A prison or detention center. D. Another place the sampler considers is appropriate in the circumstances. 478 How DNA samples may be taken. A DNA sampler may take a DNA sample from a person only by A. having the person use a mouth swab to swab the person's mouth, or collecting hair, including roots of the hair, from the person. 365 or S. Without warrant. 1. It is lawful for a police officer, without warrant, to arrest an adult the police officer reasonably suspects has committed or is committing an offense if it is reasonably necessary for one or more of the following reasons. A. To prevent the continuation or repetition of an offense or the commission of another offense, to make inquiries to establish the person's identity, to ensure the person's appearance before a court, to obtain or preserve evidence relating to the offense, to prevent the harassment of or interference with a person who may be required to give evidence relating to the offense, to prevent the fabrication of evidence. Page 17. To preserve the safety or welfare of any person, including the person arrested, to prevent a person fleeing from a police officer or the location of an offense. 282 Application for authority to acquire or use assumed identity. 1. A law enforcement officer of a law enforcement agency may apply to the chief executive officer of the agency for an authority for the law enforcement officer or another person to do either or both of the following. A. Acquire an assumed identity. Use an assumed identity. 2. A separate application must be made for each assumed identity to be acquired or used. 3. An application A must be in writing in the form decided by the chief executive officer, and must contain all of the following information. I. The applicant's name. 2. If a person other than the applicant is to be authorized to acquire or use an assumed identity, that person's name. I guess I could also be considered a terrorist if you view writing to be an action, and this body of work to be an ideological cause, as the Terrorism Act 2002 clearly states. 3. Definition of Terrorist Act. 1. General in this act. Terrorist act means an action where the action falls within subsection 2 and does not fall within subsection 3 and B. The action is done with the intention of advancing a political, religious, or ideological cause. Fines. Courts and presentments. In this section I will attempt to cover as much as possible in regard to handling offers by policy enforcers, lawyers and courts. Let me preface this by saying that I believe in justice and common law, and cannot tolerate criminals or violence toward anyone or anything. This information is to assist the good people out there to deal with the injustice, brute force and revenue collection of a system out of control, doing whatever it pleases. With any presentment, present, or offer to contract, you have 72 hours to return their documents to them, accepted for value and consideration upon proof of claim. Render to Caesar the things that are Caesar's, and to God the things that are God's. And they marveled at him. Mark 12:17 KJV. Now, if you believe in a God or not, that is none of my concern. I personally believe that the all there is, the energy or force that creates everything, that may be called the universe or God or whatever label you put on it, is part of us, and we are part of it, so we are all one. There is no page 18. Separation. The law of attraction states that we attract through vibration and thought, all that comes into our lives, and I have proven this countless times, both good and bad. Whatever you focus on is what you attract, and however you feel is predominantly what will come back to you to support that feeling. Therefore, our world is co-created by us, by conscious thought and unconscious feelings. The statement about Caesar is important, because within common law, the law of the land and original jurisdiction, it is a return to, or use of the laws laid down by God, as the highest authority. It is a rejection of man-made statute laws and a claim of your natural inalienable birthrights. I never fully comprehended this when I began, because I never believed in God or religion, and when I was a teenager and had to attend court, I refused to swear on the Bible. Little did I know I was rejecting my remedy under common law. Religion comes from the term liege lord, owing allegiance to a lord, and so religion means to separate yourself from the source. I believe religion to be the cause of much of the world's problems today, as it is the opposite of spirituality. You see, there is a hierarchy that goes something like this: God created man, man created government, government created states, states created laws, and so on. In this system you can see that whatever is created cannot be superior to the creator, so the only way that government or their man-made laws can have authority over you is by your consent. Government created the Strawman, which is why it claims authority over it. Your duty is to rebut the presumption that the legal fiction person they created is the same thing as a living life force or soul, within the body of a man or woman. The terms they will always use when referring to the person are defendant and debtor. Remember, you are the principal creditor, so you don't want to be seen appearing as the defendant or debtor. Summons to debtor. Criminal law, Sentencing Act Section 66. After all, the court is really just a bank in disguise, and it's all about revenue. Revenue means to change place, or to change position, just as resource is the taking away or returning what is yours. As you can see by the opening statement below, it's only money they are interested in, not justice or truth. In my experience, the primary goal of any legal fiction is to extract something from you to keep it alive, and to do that they ask you to pay. Page 19. Because you were born into a world without any lawful money in circulation, backed by anything of value, the government is essentially bankrupt. The real value lies in the physical form of the person, citizen and resident that has enjoined it and become a legal fiction. Let's have a look now at some documents and court notices so that you can begin to familiarize yourself with the illusion, and how you can deal with these presents or offers to contract. If you are asked or forced to sign a form such as this, you are being asked to become the surety for the defendant, the person, and accept responsibility for its debts or charges, energy, that the fiction court needs to keep it alive. You should always write under your signature signed under duress and threat of harm, kidnap, rape, pillage and plunder. This is essentially a contract or covenant, and in contract law if you are forced to sign, you can rescind your signature, rendering it invalid. When dealing with courts, lawyers, police and other authorities, it's important to stay in honor. That way you won't dishonor their presentment, offers or the court, which can lead to contempt. Page 20. Here is a letter I prepared for someone who had been arrested for what amounted to a ridiculous claim and minor offense. He was taken to the station for processing, and given a notice to appear in court. The original court notice was taken back to the registrar of the court within 72 hours with this cover letter stapled to it. Filled out with his details, notice of conditional acceptance notice to appear. I refer to the attached notice dated, and advise that your offer to assume jurisdiction and your instrument have been accepted for value and consideration, upon proof of claim, and returned without dishonor within 72 hours. For and on behalf of Job Henry Doe, trademarked by signature John Henry of the Doe family, principal creditor, all rights reserved, waiving none ever, in my correct capacity as beneficiary of the original jurisdiction. Permission must be sought in all matters of privity where mutuality of interest occurs. The registrar of the court accepts and stamps the documents, and you can ask for a copy for your records. If they won't make a copy for you, you can take them and make a copy, then bring the originals back and hand them in. This usually cancels out the hearing, as there is no jointer and no proof of claim. It's just an allegation or hearsay. When the court hearing came up, however, the case was still listed, so he appeared, not as the defendant, but as the principal creditor. The court hearing certainly didn't go the way the magistrate, judge, was expecting, as I had instructed him how to speak in court, and apparently the magistrate turned red and started yelling. They hate it when you stand your ground and they can't get jurisdiction. He finally gave up and set the matter for trial. We believe in this case that the registrar either destroyed or didn't file the documents, as they had displayed a personal reluctance to accepting them. This can and does happen. I had one grumpy registrar scrawl a big line through my carefully prepared document one time, and say you can't do that. I asked, is that a law or your opinion, and are you giving me legal advice? They binned my document, so I went home, made another copy, and took it to the main city court, who had no problem with it whatsoever. In fact, it cancelled out the other court's presentment, and I never heard another thing. That was 2 years ago. In his case, he has been forced to sign the bail notice, fortunately the way I had taught him, but then I prepared the flowing affidavit for him to take that bail notice back within 72 hours. Study the way the affidavit is presented. You should try to avoid arguments, controversy in claims or statements that could be taken as evidence, rather the use of negative averment, which is how point 5 is structured, as it places the burden of proof upon the claimant. Page 21. Again, it's not possible for me to write a custom reply or template that will suit every situation. The important thing is to read between the lines, and see exactly what it is they are saying, and rebut that presumption. Most importantly, keep it simple. I have seen affidavits with 70 or more points, which is completely unnecessary and reduces your chance of it being accepted or understood, simply because people have short attention spans. Effective use of words can be a powerful remedy against even the biggest commercial lawyers and solicitors. Remember, they are just actors, hired to play a part. They have no first-hand personal knowledge, and no subject matter jurisdiction. It is really legal trespass. The flowing affidavit can be used or modified to suit similar situations, but as with all the documents, it must address your specific case, and you need to learn how to recognize what the offer is, and accept that for value upon proof of claim. Affidavit I. John Henry of the Doe family, a living spirit within a man, and principal creditor for Mr. Job Henry Doe T. Legal fiction word mark and intellectual property, in care of, insert address. Humbly apologize for any and all dishonors and misunderstandings that may have occurred, and make oath and say, 1. I hereby rescind my autograph on the document known as notice to defendant of undertaking as to bail, as I was forced to sign under duress and threat of kidnap, harm, rape, pillage and plunder, fearing for my safety and causing me to not think clearly, thereby making any contract null and void. 2. With regard to any notice to appear, presentment or other instrument inviting me to a building known as a court, I accept your offer to assume jurisdiction upon proof of claim and decline to attend, as I am of the opinion that I do not understand any court matters, and therefore do not have the standing or jurisdiction to speak or be heard. 3. I have not seen, nor am I in possession of any proof which shows that the legal fiction wherein Mark can physically do anything, and believe none exists. 4. I have not seen, nor have I been presented with any proof that the notice of conditional acceptance filed with the registrar of the court on, insert date, along with the original notice to appear, returned within 72 hours of receipt, without dishonor is not a valid settlement. 5. I have not seen, nor been presented with any evidence which shows that a justice of the peace or prescribed police officer signing a notice to defendant of undertaking as to bail can offer legal advice, coerce or try to prevent me from signing in my correct and proper manner, as the principal creditor for the legal person, Mr. Job Henry. Trademark and believe that none exists. For and on behalf of Mr. Job Henry. Trademark legal fiction by insert signature page 22. John Henry of the Doe family, principal creditor, all rights reserved, waiving none ever in my correct capacity as beneficiary of the original jurisdiction. Permission must be sought in all matters of privity where mutuality of interest occurs. Sworn at by the said John Henry of the Doe family, this day of (2009) before me, justice of the peace, proclaimed manager of a bank, building society or credit union, or any person if approved as a commissioner for taking affidavits accepted for value stamp, insert their contact details, your reference, insert their reference number, received via mail, insert receipt date, reply, returned, insert reply date must be within 72 hours, page 23. Notice of conditional acceptance. Job Henry. Trademark, your presentment has been accepted for value and consideration upon proof of claim and returned without dishonor. I have not seen, nor am I in possession of, any material fact, evidence or otherwise, that demonstrates 1. Proof of claim of any allegation, sworn to be absolutely true and correct, not misleading or based upon hearsay or presumption. You have established subject matter jurisdiction and have first-hand personal knowledge to make any such determination, that the debtor is a living spirit within the body of the man, and not a corporate entity, or other fictitious word, mark, or trade name. There is any lawful money in circulation, backed by anything of value with which to pay. 5. The specification of the unit of measure known as the dollar. Unless the lawful document which provides proof of claim of each item is supplied within 7 days from the date of this letter, I shall assume that there is none and the matter is settled. For and on behalf of Job Henry. Trademarked by insert signature John Henry of the Doe family, principal creditor, reserving all unalienable God-given rights, powers and privileges, waiving none ever, in my correct capacity as beneficiary of the original jurisdiction. Permission must be sought in all matters of privity, where mutuality of interest occurs. Jurisdiction. There are many things that you can say to a police officer, policy enforcer, that will rebut the presumptions that they will offer you. Let's have a look at a hypothetical situation. Officer, can I see your license, please? You, hello there, what seems to be the problem? Officer, do you have a license on you? You, is there a charge, officer? Officer, not as yet. Now can I see your license, please? You, well, if there's not a charge, officer, am I free to go? Officer, could you step out of the car, please? You, I'm sorry, is this a transaction of a securities exchange? Because if it is, then you require my permission, and if it's not, then you won't be generating anything which gives me an obligation. Page 24. Officer, look, I just want your name. Well, I'd like to help you out, but I don't know if you're acting lawfully or legally. So I don't know if you want my lawful name or my legal name. Officer, I'm acting legally, so please tell me your legal name. Can you show me that I have an obligation to have such a thing? Officer, all right, then let's say I'm acting lawfully. What's your lawful name? Oh, well, that's different. How do you do? I'm Thomas. Officer, that's better. Now what's your last name? Well, I don't have a last name. I have a family name. Officer, what's your family name then? If you're acting lawfully, then why do you need that? You can see what is happening here. The officer is trying to get the name of a legal person to be able to write out a ticket for whatever offense or code or number you may have violated. You wonder sometimes how it's possible to violate a number, but that's the insanity of law. There are literally millions of laws and codes and statutes and acts, and how many of you out there know anything about them, or have ever read one, let alone comprehend its meaning? The fact is that in the original jurisdiction, there were 10 commandments. That is God's law. There is no possible way for anyone to understand statute law, so why bother trying? One of the things you'll see in the documents here is the statement, I do not understand. Understand does not mean comprehend. It means to place yourself in a legal position beneath the magistrate or other assumed authority. They are asking you to stand under them and their laws. So if you say yes, then it means they have full jurisdiction over you, and you will be enjoined with a person, Strawman, as the defendant. Transport. The word transport means the transfer of something from one port to another port. This indicates that it is under maritime law and admiralty jurisdiction and as such is regulated, policed or taxed. The Department of Transport will explain that your car is considered a class of vehicle. Under the bonnet, you will find vehicle identification plates, vans, and other identifying numbers stamped into the firewall and engine block, so forget any idea you have that it's your car, or that it's private. Your home, work, shopping center, center of commerce, school, or any place you take your car are all considered ports of call that you navigate between. Many people now have navigation to guide their vehicles just as the ancient mariners had maps and charts, but instead of stars to guide us, we have satellites. Other modes of public transport exist for the person, especially for those of you who rely upon the use of a benefit from the state, fiction. Depending on what type of person you are classed as, pensioner, student, adult, etc., you will have to pay a different fee for the use of it, and will be required to display the corresponding concession card or ID that you have applied for. So what exactly is being transported, or moved around? Page 25. In the case of a truck carrying goods, you could see it was the cargo, but in the case of a train or bus or family car, it is the persons on board. This term originally comes from boarding a ship via a plank of wood. The Strawman and its commercial energy is being transferred from one port, location, to another port, along the established shipping routes or lines. Notice how a bus route or train line have the same naval terminology as the shipping lanes and trade routes. They have departure times and destinations. There are seaports and airports, and some of you have port passes, passports, that allow you to take your Strawman or person to other countries. You become the self-floating baggage in a securities or foreign exchange. This photograph was taken inside a train. It shows that a train is also considered a vehicle. A vehicle is really any commercial mode of transport. If your person does not offer up some sort of ticket to validate its trip and thus record the movement of persons and their energy throughout the state, then be prepared for the policy enforcers to step in and penalize your real self as a surety. I snapped this photo of people disembarking from a passenger train to find 5 police officers, 3 security guards, plus transport staff, police dogs and paddy wagons waiting for anyone who hadn't bought or validated their $2.60 ticket. Driving is a commercial activity, which is putting a motor vehicle into motion, empowering it. It requires licenses, rules, regulations, laws and permission from the state. Each vehicle is registered to the state and in essence owned by them, and you have a title and license to use it. Why do you think they want to know where it is garaged? Without that endorsement or permission, the vehicle is useless, unless driven on private property. You cannot put it into motion without license or registration because the state, fiction, does not benefit from the energy flow that you, as the animator of dead things, supplies. It is also concerned with possible risk to its other property, such as persons and vehicles that it is extracting energy from. Page 26. Think about this in relation to court when it is moved by your energy. You could say that the fiction government is primarily set up to control movement. It's like a spider sitting in a web, waiting patiently for a vibration to indicate a potential prey. Speaking of spiders and webs of deceit, it's not surprising what greets you at the entry to the Hague Court. A giant spider sculpture at the Hague Court, one of many around the world in places of power, forming a global web. Getting back to the issue of what is being transported, this should explain why laws such as wearing seat belts and helmets are there, not for your protection, but for the protection of the Strawman. The registration, insurance and license are the means of regulating and covering any risk of commercial loss. You have to remember that all of this illusion of separateness is just that, an illusion. Now you understand why the policy enforcers can do whatever they like when you're on the road in your vehicle, and why they ask for your license, to get the person's name and enjointer, and why you get fined for any breach of the Transport Act, or any petty thing they can think of. They need someone to stick with the bill. You'll notice that at this stage it's only an allegation, which means that it hasn't yet been proven. It's an offer that requires you to make a choice between silence, argument, acceptance or conditional acceptance. You can also see the watermark of the Crown on this infringement notice, and the act that the fiction created hoping you will play a part and give it some of your commercial energy. Let's take a look at some sections and definitions from the Motor Vehicles Act 1959. Remember, all of these definitions relate to the person, Strawman. You can see that what you page 27. Thought where common words are in fact inventions or alterations of the English language to mean something else. Road means an area that is open to or used by the public and is developed for, or has as one of its main uses, the driving of motor vehicles. Commercial motor vehicle means a motor vehicle constructed or adopted solely or mainly for the carriage of goods, including a motor vehicle of the type commonly called a utility, and a prime mover. Trailer means a vehicle that is built to be towed, or is towed, by a motor vehicle, but does not include a motor vehicle that is being towed. Motorbike means a motor vehicle, not being a trailer, with two wheels, and includes a two-wheeled motor vehicle with a sidecar attached to it that is supported by a third wheel. Motor vehicle means a vehicle that is built to be propelled by a motor that forms part of the vehicle. Operator, in relation to a motor vehicle, means the person principally responsible for the operation or use of the vehicle. Registered operator, in relation to a motor vehicle, means a person recorded on the Register of Motor Vehicles as the operator of the vehicle. Registered owner, in relation to a motor vehicle, means a person recorded on the Register of Motor Vehicles as the owner of the vehicle. Vehicle does not include a vehicle operated on a railway or tramway or a mobile machine controlled and guided by a person walking. 9. Duty to register. 1. A person must not drive an unregistered motor vehicle or cause an unregistered motor to stand on a road. 2. A motor vehicle must not be driven on roads without registration or insurance under Part 4 as authorized by subsection 1, unless there is in force a policy of public liability insurance indemnifying the owner and any authorized driver of the vehicle in an amount of at least $5 million in relation to death or bodily injury caused by, or arising out of, the use of the vehicle on roads. A person who drives a motor vehicle on a road without registration or insurance under Part 4 as authorized by this section must, if requested by a member of the police force to do so, produce evidence of the person's public liability insurance either forthwith to the member of the police force who made the request, or be within 48 hours after the making of the request, at a police station conveniently located for the driver, specified by the member of the police force at the time of making the request. 47D offenses in connection with number plates. 1. A person must not. Page 28. Drive on a road, or cause to stand on a road, a motor vehicle to which is attached a number plate that bears a number other than a number allotted to the vehicle, or B. Drive on a road, or cause to stand on a road, a motor vehicle to which is attached a number plate that has been altered, defaced, mutilated or added to, or C. Drive on a road, or cause to stand on a road, a motor vehicle to which is attached a colorable imitation of a number plate, or D. without lawful excuse, have in his or her possession a number plate or an article resembling a number plate that is liable to be mistaken for a number plate. Of course, all of this is very different to your inalienable rights to travel or journey on the common ways of the land, in peace, with due care and competency to do so, without license, restriction, registration, or fear of harassment, kidnap, pillage and plunder by pirates, police. The revealing statement, 2, about having at least $5 million public liability insurance tells you straight away that it's all about protecting their persons, and nothing to do with law or justice. Some of us have taken the step out of the public and into the private realm by creating our own private plates and private registration or other displayed notice. In 2006 I handed in my plates, deregistered the car, and drafted a notice to try and compel those in power within the state to challenge my inalienable rights. What happens in these cases is that you will get a letter back, probably long after your requested response time, pointing out laws such as the Motor Vehicles Act, and drawing your attention to the rights of citizens and persons, etc. Of course, there is no rebuttal or denial of what you have asked. They simply sidestep to the issue and go into voluntary dishonor, then claim no agreement or contract afterwards if you challenge them. So for nearly 2 years, we journeyed in peace on the common ways of the land, until one day we were stopped by policy enforcers in the middle of nowhere. They kept myself and my wife and child there for over 30 minutes while they looked at the car, took photos, asked questions, scratched their heads, etc. I told them I had a private agreement, and was enjoying my inalienable rights to travel. They eventually let us go, as obviously there was no jurisdiction to be had. Although we enjoyed the benefits of no registration fees, using e-tolls for free, not worrying about red light cameras, etc., there was a downside. There was an underlying fear of harassment, unlawful arrest and detainment, exposing my family to police brutality and possible kidnap, plus the fear that the public, agents of the system, who are not yet unplugged, would see our car and report it, thinking they are being a responsible citizen without knowing the truth. After one particularly nasty encounter with a very aggressive officer, pirate, who wanted to board our vessel, I decided I was not going to submit to his imposed authority and interruption of our peaceful journey, so in classic Smokey and the Bandit style, eluded capture and decided to take a break until such time as I could guarantee our safety and hold the equivalent of diplomatic immunity over these policy enforcers. Page 29. Idealism does not justify placing your loved ones in danger. Remember, this is relatively new, and there are an awful lot of persons out there, so the assumption is that we are all persons. As a result of this and the ongoing research, I would not recommend following this course of action until we get to the bottom of it and establish a precedent for private automobiles and journeying in peace. I will revisit this in Book 2. Money and Debt Verification, a step-by-step guide with templates. This section of the book will deal with loans, credit cards, mortgages, debt collectors, solicitors and credit reporting agencies. It is the intention to lawfully establish that you are the source of the funds that were created, by the use of your signature on a contract, promissory note, that creates the value that is loaned back to you under the illusion of a loan of the bank's money. You've probably seen a tag on the EFT machine at the supermarket, which looks like this. PIN stands for Personal Identification Number if you didn't already know. The identity of the person. This tells you that your PIN number functions exactly the same as your signature. Your signature is what creates value, or endorses an instrument, or validates a contract. That is the most misunderstood but valuable tool we have. Since there is no lawful money, gold or silver, in circulation, backed by anything of value, the governments and banks as well as you and I, are essentially bankrupt. The pieces of paper circulating in place of money, affectionately called currency, are in reality debt notes. Worthless. What usually happens in a loan situation is that a borrower is established, being the all-caps fiction person, the strawman. The principal creditor for the strawman, you, enters into a loan contract with the bank, with the assumption being that the bank is going to give you some of its money, for which service you agree to pay them back over a period of time plus interest. However, what really happens is that the bank monetizes your instrument, the contract, with your signature, and turns it into a credit in its books, essentially a bookkeeping entry as a liability. Page 30. A liability means it owes you something, and it uses this newly created credit on its account, which is no more than ones and zeros on a computer, to then create a check or deposit those fictional digits into your account. So if you created the money, why then do you have to pay back a loan if they never loaned you anything? Exactly. Now, you have to realize that this has been going on for decades, maybe centuries, and many wars have been fought over it, so don't think the bank is going to just come right out and admit a fraud. We have to compel them to provide proof, in the form of a notice of adequate assurance. This is borrowed from the American system, but is just as effective and valid here in Australia. I have created customized templates included in this book, for your study purposes. What you do with them is entirely up to you, but I can tell you what I do with them, and will explain the process in detail, including reply letters and real-life examples. Let me make it clear that there is absolutely nothing illegal about this process, unless you're intentionally out to defraud someone, which would be wrong. This is a lawful method for compelling a bank or credit provider to give you all the details about the contract and loan, to see if they have done the right thing. It's possible that they did loan you some money, or gave you something of value, so you must always check first, and this method should always be done before canceling any payments or refusing to pay further, as it will give you just cause to do so. I will include some examples of loans that I have canceled for friends, because they asked for my assistance, and so I became their authorized agent or nominated person to act on their behalf. You may also wish to appoint someone as your agent, as it creates yet another level of separation between you and the fiction borrower. So whatever situation you may be in right now, $200 in debt or $500,000 in debt, rest assured that you have likely already paid, and owe nothing. Non-negotiable notice of adequate assurance of due performance. Registered mail hash. Insert registered mail number here. 2. Insert the name of the lender here. Hereinafter lender from John Henry of the Doe family, principal creditor for Mr. Job Henry Doe trademark. Hereinafter borrower C. O. Insert your address here, postcode within a box like this. Date. Insert the date here. 3. Loan number. Insert the loan number here. Dear officers and or agents for lender, it has come to the attention of the alleged borrower, after much research, that there is reason to believe that the alleged lender is not the holder in due course of the borrower's promissory note and or may have breached the agreement concerning the above referenced alleged loan or loan of credit. Page 31. I now request information from you regarding the details of what the entire agreement is, and if you performed according to the agreement. Since the borrower created value in the form of a promissory note, agreement to the lender to perform according to the loan agreement, The borrower is now hereby requesting adequate assurance of due performance that the lender has performed according to the loan agreement and that the original lender used their own money to purchase the borrower's promissory note as money or like money to fund the check or similar instrument that the lender then lent to the borrower, and that the lender has followed GAAP, generally accepted accounting principles and generally accepted auditing standards concerning this loan. The borrower is hereby requesting that an authorized officer or agent of the lender answer the following questions, then sign and return the attached affidavit within 30 days of the date of this notice. This is the borrower's good faith attempt to settle this matter and clear up any confusion about the terms of the agreement prior to an administrative process on the matter. 1. Is it true that the lender follows GAAP, generally accepted accounting principles? Please respond with yes or no in writing. Was full disclosure given regarding if the borrower was to provide the funding for the loan per bookkeeping entries? Please respond with yes or no in writing. 3. Does the lender accept something of value from the borrower that is recorded as an asset on the books of the lender, resulting in a new liability on the books of a financial institution? Please respond with yes or no in writing. 4. Did the lender lend the borrower the lender's money? Please respond with yes or no in writing. Is it the intent of the loan agreement that the party who funded the loan, per the bookkeeping entries, is to be repaid the money lent to borrowers? Please respond with yes or no in writing. Does the lender record an asset showing that the borrower owes money to the lender involved in the alleged loan? Please respond with yes or no in writing. Did the lender follow the Reserve Bank's policies and procedures in the account transactions? Please respond with yes or no in writing. Is it true that, according to the bookkeeping entries, the borrower funds the loan? Please respond with yes or no in writing. 9. Is it true that according to the bookkeeping entries of the lender, the borrower is the lender of the principal amount? Please respond with yes or no in writing. 10. Is it true that, according to the agreement, you received permission from the borrower to deny the borrower equal protection under the loan agreement? Please respond with yes or no in writing. 11. Is it true that the lender violated GAAP, generally accepted accounting principles, thus making the agreement null and void? Please respond with yes or no in writing. 12. Is it true that the lender converted the promissory note agreement by using it as value to give value to a check or similar instrument as proven by the bookkeeping entries, thus proving that the borrower funded the loan and proving that the lender used false statements that the lender funded the loan? Please respond with yes or no in writing. Page 32. This notice in no way constitutes repudiation in any form by the borrower. However, if it cannot be shown or proved beyond reasonable doubt that you have not breached the agreement or loaned the principal amount out of your own funds, not the value, money created by the promissory note, then the following is requested within 30 days. A. Any outstanding amount of the alleged loan is to be balanced and returned to zero. B. Statement showing the discharge of the alleged debt showing zero balance. C. A guarantee that no report of delinquency or bad credit shall be given to any credit reporting agencies. Failure to respond will be deemed a dishonor of this notice. Notice to principal is notice to agent, and notice to agent is notice to principal for and on behalf of Mr. Job Henry Doe, trademark by insert your signature here, John Henry of the Doe family, principal creditor, all rights reserved. Permission must be sought in all matters of privity where mutuality of interest occurs. Note: if you are using someone to act as your agent, then the from line and signature would look like this: from Jane Doe, authorized agent for John Henry of the Doe family, principal creditor for Mr. Job Henry Doe, trademark, hereinafter borrower sincerely, insert agent signature here, Jane Doe, authorized agent for John Henry of the Doe family, principal creditor for Mr. Job Henry Doe, trademark. He will also need to include an authority notice giving the bank or loan company permission to reveal details of your account to the agent, if you are using one. You can request one of these from a bank, but be careful when doing so, as they often try to get you to recontract by asking for government-issued ID or other details that you are not required to give. They are merely trying to establish if you are the creditor or debtor, and if your identity Fication has an enjointer whereby you have signed as the all-caps fiction and become one with the Strawman, then unfortunately you are the debtor. Here is an example of a letter of authority from Ch. It is reproduced here for educational purposes only. You can see that I have made some modifications to the information and layout to properly reflect your position as the principal creditor, because by default, all government and banking forms are laid out with the assumption that you are the debtor person. Page 33. You can see I have crossed out birth date and written creation date, which is correct for the fiction, as it is the medium between the living and the dead. I have also added the correct signature in the box that says borrower, as obviously the borrower is a fiction and cannot sign for itself. This is the affidavit to include for the bank to fill out and sign, making a total of 3 documents you need to prepare and send by registered post. State of affidavit: the undersigned affiant, being duly sworn on oath, deposes and says that he or she is an officer of that he or she, as an officer of, having held said note, has the authority to execute this affidavit on behalf of the company and to bind the same to its provisions. The loan agreement had the following terms. 1. Follows GAAP, generally accepted accounting principles. 2. The intent of the loan agreement was that the party who funded the loan, for bookkeeping entries, is to be repaid the money loaned. 3. According to the bookkeeping entries, use their money as adequate consideration to purchase the promissory note of whoever. 4. The promissory note was not used as value to give value to a check or similar instrument or account. 5. I affirm that I understood the terms and conditions of the loan agreement signed under penalty of perjury. Signature of officer, full name sworn to and subscribed before me this day of my commission expires. Registered post: the use of registered post with all of the work that you do ensures a number of things. Firstly, you get a tracking number which you can record and check to see if it has been delivered. Secondly, if you correctly choose to tick the delivery confirmation box, you will get a return receipt, signed by the person you sent the letter to, or their agent. Third, you have proof that you did actually send the letter on a certain day, and the return receipt shows the date they received it. Ask your local post office clerk if you have any questions about filling out the forms. Of course, this only proves postage, not the contents, so you can also get a witness to fill out a proof of postage such as this one, to validate the content if you wish, but it is not usually necessary. Proof of service: I do hereby affirm and attest that. Page 35. 1. I am over the age of 18, of sound mind and, further, not a party to or interested in any way in the outcome of the matter addressed in the enclosed documents. My mailing location is, insert address 1. On, insert date, I personally mailed in a registered post envelope, # with delivery confirmation requested at an Australia post office located at, the document entitled Notice of Adequate Assurance, or other document title, on behalf of John Henry of the Doe family, to, insert name and address of the person or company 1. I further declare under the laws of the state of, insert state, that the foregoing is true and correct. Executed this day of, insert date and your signature printed name. There are many things that could happen along the way in this process. I have personally experienced everything from absolute silence, tacit agreement by dishonor, to all kinds of argument, controversy and harassment or threats, all of which has absolutely no consequence on the outcome of this method. Unless they can answer your questions point by point and provide a signed affidavit to verify that the loan is not bogus, then you have to assume that it is, and that something fraudulent is going on that they will try and cover up. The redraw, this is where they will try and call or write to you to get an enjoinder with the Strawman debtor if they think you're on to them. Remember, the caller, probably from India, is looking at a screen which shows the borrower's name in all capital letters, and is in fact asking you, is that John Doe? If you reply yes, then you have just placed on record, as all calls are recorded for quality and training purposes, that you are the debtor, borrower. The best way to answer the phone is like this. You, hello caller. Hello, is this Mr. John Doe? You, can I ask who is calling please? Caller, this is a private matter for John Doe, is that John? You, I'm sorry, who is this? Caller, it's a private matter for John Doe, is he there? You, I'm sorry, if you cannot tell me who you are, then I certainly am not going to tell you who I am. You obviously have the wrong person. Page 36. Caller, this is Trans-Pacific and this is a private matter for John Doe, but because of the Privacy Act one cannot discuss anything with you until I establish who you are. You, well, if you don't know who I am, then why are you calling me? I do not do any business over the phone, so if you have anything to say, please write it down and post it to me if you think you know my name and address. Have a nice day. Then hang up. Do not argue, get into the controversy, explain anything, admit anything, confirm anything, or otherwise create an invisible contract that they can use against you. Okay, let's assume that you haven't had anything from the bank or credit card company after 30 days of receipt of your registered post return receipt. The next letter to send is this one, along with the second copy of the affidavit. At this point they are in dishonor, and you are going to give them a second chance to redeem their honor before proceeding. Fill it out the same way as before. Non-negotiable notice of default and demand from hereinafter borrower to, in his private capacity, bank agent for hereinafter lender date. Notice of default and demand to cease and desist collection activities prior to validation of purported debt tiers. You have chosen not to respond to my request for adequate assurance, or return the affidavit enclosed with it. The borrower has become suspicious of your activities and the validity of the agreement. This constitutes timely written notice that the borrower now disputes the entire amount of the alleged loan and declines to pay the purported debt, which, unless I hear from you, I will discharge and cancel in its entirety, without dishonor, on the grounds of breach of contract, false representation, and fraud in the inducement. Failure to answer my previous correspondence tells me that you acknowledge that the borrower funded the alleged loan and the loan agreement was stolen and forged, thus ending any claim you have against him. If you have evidence to validate that your claim does not constitute fraudulent misrepresentation and that the borrower owes this alleged debt, this is a demand that, within 7 days, you provide such validation and supporting evidence to substantiate your claim. Until your claim is validated, you have no authority to instigate any collection activities. This is actual notice that absent the validation of your claim within 7 days, you are prohibited from contacting the borrower at his home or at work. You are further prohibited from contacting his employer, bank, or any third party. Each and every attempted contact will constitute harassment and defamation of character and will subject your institution and any agents in her private capacities who take part in such harassment and defamation to a liability for statutory damages of up to $1,000, and possibly a further liability for legal fees to be paid to any counsel which he may retain. Page 37. Absent such validation of your claim, you are prohibited from filing any notice of lien and/or levy, and are also barred from reporting any derogatory credit information to any credit reporting agency. Verification requires confirmation of correctness, truth, or authenticity by affidavit, oath, or deposition. In accounting, it is the process of substantiating entries in books of account, Black's Law Dictionary, 6th edition. This verification should include signing the enclosed affidavit verifying the terms and conditions of the alleged loan and answers to questions provided. You should be aware that sending unsubstantiated demands for payment through the Australian postal system might constitute mail fraud under federal and state law. You may wish to consult with a competent legal advisor before your next communication with me. Your failure to respond on point within 7 days to satisfy this request will be construed as your absolute waiver of any and all claims against the borrower, and your tacit agreement to compensate the borrower for costs including any counsel he may seek. For and on behalf of Mr. Job Henry Doe, trademarked by insert your signature here, John Henry of the Doe family, principal creditor. This time you are giving them 7 days to respond, 72 hours commercial time plus postage time note, with any and all presentment, notices or letters. To be within honor, you only ever have 72 hours to respond. They may try to trick you into dishonor by saying you have 30 days or whatever, but don't be fooled. Respond immediately. This is vital with court documents. A notice will not appear in a registrar within 72 hours, and that is your time to rebut the presumptions and return their documents, accepted for value, upon proof of claim. We'll go into that in detail later on in the book when we discuss the A4V method. This is an example of a bank loan that I assisted someone with. He was in very bad financial trouble when he came to me, as he had over $40,000 of debt in personal loans and credit cards. Within 3 months, I had wiped them all clean, and he never paid another cent. Page 38. Note the statement at the bottom. This is the final statement to be issued for your bank's personal loan account, as this loan has now been discharged. The amount was $32,539.36. I should mention that after 30 days, if you do not get any reply from the bank or credit card company, you should stop paying any more money. Payment of an account suggests liability for it. You should also at this time send copies of your documents to the credit card reporting agencies, Dun & Bradstreet and Veda Advantage, and notice them of the default. You can include a note such as this: Aiden, Dun & Bradstreet, please find attached notice of default an opportunity to cure relating to an alleged loan from Ziz Bank. You are hereby noticed of Ziz's default and of our intent to issue an estoppel, and at no time do we authorize you to accept or report any default by my client unless we receive substantiation and proof of claim in this matter. Regards, Thomas Anderson, authorized agent for John Henry of the Doe family, principal creditor for Job Henry Doe Credit Reporting Agencies, Veda Advantage. assist.to@vedadvantage.com. Level 590 Arthur Street, North Sydney, NSW 2060, Australia. Collection House Limited. Level 7, 515 St. Paul's Terrace, Fortitude Valley, QL 4006, Australia. P.O. Box 2247, Fortitude Valley, BC, QLD 4006, Australia. Phone +61 732921000. Fax +61 738320222. Credit Corp Group Head Office. Level 11, 10 Barrack Street, Sydney, NSW 2000, GPO Box 4475, Sydney, NSW 2001. Phone +61 293473600. Fax +61 292624017. Email info@creditcorp.com.au. and B Australia. Dun & Bradstreet, Australia. Proprietary Limited. Dun 7534071770, ACN 006399677. Client services at dnb.com.au. Level 16, 383 Kent Street, Sydney, NSW 2000. T 02827028000, F 02827028666. Page 39. From their website, DNB collects personal information to provide the products and services we offer. These services include commercial and consumer credit reporting, receivables management including debt collection services, other information services including marketing databases for direct mail, telemarketing, other sales activities and market research. Accessing and correcting personal information. DNB's Public Access Center. Respond to requests from individuals for access to their personal information. Clear guidelines are available on our website www.dnb.com.au for individuals on how to access their personal information. DNB prides itself on exceeding the regulated time frames for supplying an individual with their consumer file, and encourages individuals to manage their credit arrangements effectively by receiving a copy of their own credit information file. Notice the mention of correcting personal information, which is what we will be compelling them to do if no verification of debt is provided. The following documents relate specifically to credit cards and mortgages. Each are slightly different in wording to accommodate things such as the return of title deed, etc. I should point out that at the time of writing this, that I am still in the process of trialing the mortgage documents. I therefore offer no evidence of success in that area just yet. Put resolution process. What you need to know. Veda Advantage Information Services and Solutions Limited. Veda Advantage collects from and discloses information to credit providers and others. We do this in accordance with the Privacy Act 1988, 100th, the Act. Veda Advantage does not make recommendations about whether or not an application for credit should be accepted. This decision is made by the credit provider. Their decision may be based on factors such as their lending criteria, the information you gave on your credit application, or the information on your credit file. We take reasonable steps to ensure your credit file is accurate, up-to-date, complete, and not misleading. Our investigations team will investigate any complaint you have regarding your credit file and act on your behalf to mediate any dispute you have with a credit provider in relation to your credit file. It is always a good idea to take up any issue you may have relating to a particular credit provider with that credit provider first. Most credit providers have their own investigations team who can help with your dispute. Under the Privacy Act 1988, you have the right to place a statement on your file, page 40. If we do not make the amendment you requested, you may place a statement on your file about the amendment you sought. Your statement can be up to 150 words in length and will need to be provided to us in writing. Notify credit providers of any amendments made. If an amendment has been made as a result of our investigation, you have the right to notify us in writing that you require Veda Advantage to write to any credit provider who has accessed your file in the previous 3 months and tell them of the amendment we have made. Please forward your request to Investigations Team, Mail, P.O. Box 964 North Sydney, SW 2059, Fax 0299517666. Email assist@vedadvantage.com. Complain to the Office of the Privacy Commissioner if Veda Advantage does not make the requested amendment, or you are dissatisfied with the actions taken in relation to your complaint, or you are unhappy about an act or practice of Veda Advantage as a credit reporting agency. Contact our customer relations team. In addition to your rights under the Act, Veda Advantage provides you with an opportunity to have your complaint re-investigated. If you are unhappy with the outcome of our investigation, you can contact our customer relations team, who will review the investigation and re-investigate your complaint. Send your information to Customer Relations Team, Mail, P.O. Box 964 North Sydney, SW 2059, Fax 0299511766, phone 0299517564. Email customerrelations.to@vedadvantage.com. How to contact the Office of the Privacy Commissioner or the Financial Ombudsman Service. If you are unhappy with the outcome of our investigation, you may, if you wish, refer your dispute for external dispute resolution. When contacting the Privacy Commissioner, include the following: a copy of your credit file, information about your dispute, copies of any correspondence from our investigations team and the credit provider. Please send your information to Director, Compliance, Office of the Privacy Commissioner, Mail, GPO Box 5218 Sydney, SW 2001, Fax 0292849666, phone 1300363992. Email privacyprivacy.oov.o, page 41. For further information about the Office of the Privacy Commissioner, you can visit their website www.orvf.av.o. How to contact the Financial Ombudsman, where the complaint relates to information added to your credit file by a financial institution. You can also contact the FOS to investigate the actions that have been taken in relation to your dispute. Please send your correspondence to the Financial Ombudsman Service Mail, P.O. Box 1999, Carlton Vic 3053, phone 1-800-337-444, website www.obio.work.to. Contact Beta Advantage for any further question or queries. Please contact our customer service team on 1300-762-207 or visit our website on www.mycredit.com. Beta Advantage Information Services and Solutions Limited. ABN 26000602-862. Info page sent to me by Beta Advantage. The following notice has been formulated specifically to address a credit card provider such as Visa or MasterCard and includes many more questions that are specific to the way the account operates. Don't use it for personal loans. Notice of adequate assurance of due performance, registered mail, the manager or authorized agent for hereinafter lender. Principal creditor for all caps Strawman trademark, hereinafter borrower C.O. address, postcode and bracket state, credit card, account number, dear manager and or agents for lender. It has come to the attention of the alleged borrower, after much research, that there is reason to believe that the alleged lender is not the holder in due course of the borrower's promissory note and or may have breached the agreement concerning the above referenced alleged loan or loan of credit. This debt is therefore disputed. Before payment is tendered, I want to know the details of what the entire agreement is, and if you performed according to the agreement, since the borrower paid money in the form of a promissory note agreement to the lender to perform according to the loan agreement. The borrower is now hereby requesting adequate assurance of due performance that the lender has performed according to the loan agreement, page 42. And that the original lender used their own money to purchase the borrower's promissory note as money or like money to fund the check or similar instrument that the lender then lent to the borrower, and that the lender has followed GAAP, generally accepted accounting principles and generally accepted auditing standards concerning this loan. The borrower is hereby requesting that an authorized officer or agent of the lender answer the following questions. Then sign and return the attached affidavit within 30 days of the date of this notice. This is the borrower's good faith attempt to settle this matter and clear up any confusion about the terms of the agreement prior to an administrative process on the matter. 1. Is it true that when a credit card holder signs a purchase receipt, that the receipt is used as a bank asset to give value to a check or similar instrument or credit to a bank account, resulting in a new bank asset and new bank liability? Please respond with yes or no in writing. 2. Is it true that the credit card company follows GAAP, generally accepted accounting principles? Please respond with yes or no in writing. 3. Was full disclosure given regarding if the credit card holder was to provide the funding for the credit card loan per bookkeeping entries? Please respond with yes or no in writing. 4. Does the credit card company accept something of value from the credit card holder that is recorded as an asset on the books of a financial institution, resulting in a new liability on the books of a financial institution? Please respond with yes or no in writing. 5. Did the credit card company lend the credit card holder the credit card company's money? Please respond with yes or no in writing. 6. Is it the intent of the credit card loan agreement that the party who funded the loan, per the bookkeeping entries, is to be repaid the money lent to borrowers? Please respond with yes or no in writing. 7. According to the bookkeeping entries of the credit card company or financial institution, When a credit card holder purchases merchandise with the credit card, does the credit card company or financial institution involved in the alleged loan accept a new asset from the credit card holder that funds the loan to the credit card holder in the same transaction? Please respond with yes or no in writing. 8. Does the credit card company or financial institution involved in the credit card loan record an asset showing that the credit card holder owes money to the credit card company or financial institution involved in the alleged loan? Please respond with yes or no in writing. 9. Did the credit card company follow the Reserve Bank's policies and procedures in the credit card transactions? Please respond with yes or no in writing. 10. Is it true that, according to the bookkeeping entries, the credit card holder funds the loan to the same credit card holder? Please respond with yes or no in writing. 11. Is it true that according to the bookkeeping entries of the credit card company, the credit card holder is the lender to the credit card company? Please respond with yes or no in writing. Page 43. 12. Is it true that, according to the bookkeeping entries of the credit card company or financial institution involved in the alleged loan, new money or credit is created when the credit card holder uses the credit card to make a purchase? Please respond with yes or no in writing. 13. Is it true that, according to the agreement, you received permission from the credit card holder to deny the credit card holder equal protection under the loan agreement? Please respond with yes or no in writing. 14. Is it true that, according to the agreement, the credit card holder agreed to economics similar to stealing, counterfeiting and swindling? Please respond with yes or no in writing. 15. Is it true that the credit card company violated GAAP, generally accepted accounting principles, thus making the agreement null and void? Please respond with yes or no in writing. 16. Is it true that the credit card company converted the credit card agreement and/or credit card purchase receipts by using the agreement and/or credit card purchase receipts as value to give value to a check or similar instrument as proven by the bookkeeping entries, thus proving that the credit card holder funded the creded card purchases and proving that the credit card company used false statements that the credit card company's money funded the credit card purchases? Please respond with yes or no in writing. 17. Is it true that the credit card company violated the matching principle of GAAP and that if the credit card company accepted an asset from the credit card holder, the credit card company did not credit the liability account showing that the credit card company owed money to the credit card holder for the asset received from the credit card holder? Please respond with yes or no in writing. Failure to respond will be deemed a dishonor of this notice. Notice to principal is notice to agent and notice to agent is notice to principal for and on behalf of Mr. Job Henry Doe trademarked by insert your signature here John Henry of the Doe family principal creditor mortgage notice non-negotiable notice of adequate assurance of due performance registered mail #2 hereinafter lender from authorized agent for principal creditor for all caps Strawman hereinafter borrower C.O. address postcode page 44. Date, loan number, dear officers and or agents for lender. It has come to the attention of the alleged borrower, after much research, that there is reason to believe that the alleged lender is not the holder in due course of the borrower's promissory note and or may have breached the agreement concerning the above referenced, alleged loan or loan of credit. I now request information from you regarding the details of what the entire agreement is, and if you performed according to the agreement. Since the borrower created value in the form of a promissory note, agreement to the lender to perform according to the loan agreement, the borrower is now hereby requesting adequate assurance of due performance that the lender has performed according to the loan agreement and that the original lender used their own money to purchase the borrower's promissory note as money or like money to fund the check or similar instrument that the lender then lent to the borrower and that the lender has followed GAAP, generally accepted accounting principles and generally accepted auditing standards concerning this loan. The borrower is hereby requesting that an authorized officer or agent of the lender answer the following questions, then sign and return the attached affidavit within 15 days of the date of this notice. This is the borrower's good faith attempt to settle this matter and clear up any confusion about the terms of the agreement prior to an administrative process on the matter. 13. Is it true that the lender follows GAAP, generally accepted accounting principles? Please respond with yes or no in writing. 14. Was full disclosure given regarding if the borrower was to provide the funding for the loan per bookkeeping entries? Please respond with yes or no in writing. 15. Does the lender accept something of value from the borrower that is recorded as an asset on the books of the lender, resulting in a new liability on the books of a financial institution? Please respond with yes or no in writing. 16. Did the lender lend the borrower the lender's money? Please respond with yes or no in writing. 17. Is it the intent of the loan agreement that the party who funded the loan for the bookkeeping entries is to be repaid the money lent to borrowers? Please respond with yes or no in writing. 18. Does the lender record an asset showing that the borrower owes money to the lender involved in the alleged loan? Please respond with yes or no in writing. 19. Did the lender follow the Reserve Bank's policies and procedures in the account transactions? Please respond with yes or no in writing. 20. Is it true that, according to the bookkeeping entries, the borrower funds the loan? Please respond with yes or no in writing. 21. Was it true that according to the bookkeeping entries of the lender, the borrower is the lender of the principal amount? Please respond with yes or no in writing. Page 45. 22.1. Is it true that, according to the agreement, you received permission from the borrower to deny the borrower equal protection under the loan agreement? Please respond with yes or no in writing. 23. Is it true that the lender violated GAAP, generally accepted accounting principles, thus making the agreement null and void? Please respond with yes or no in writing. 24. Is it true that the lender converted the promissory note agreement by using it as value to give value to a check or similar instrument as proven by the bookkeeping entries, thus proving that the borrower funded the loan and proving that the lender used false statements that the lender funded the loan? Please respond with yes or no in writing. This notice in no way constitutes repudiation in any form by the borrower. However, if it cannot be shown or proved beyond reasonable doubt that you have not breached the agreement or loaned the principal amount out of your own funds, not the value, money created by the promissory note, then the following is requested within 30 days. D. Any outstanding amount of the alleged loan is to be balanced and returned to zero. E. A statement showing the discharge of the alleged debt showing zero balance. F. The surrender and return of the title deed and or other instrument that may be held as insurance to the borrower. G. A guarantee that no report of delinquency or bad credit shall be given to any credit reporting agencies. Failure to respond will be deemed a dishonor of this notice. Notice to principal is notice to agent, and notice to agent is notice to principal for and on behalf of Mr. Job Henry Doe, trademarked by insert your signature here, John Henry of the Doe family. Principal creditor default notice is the credit card notice of default is a much more complex notice, as it asks specific questions about the nature of the transactions, and lets the credit card company know that you are on to them. Not many people would suspect that the pen or PIN that I discussed earlier means that each and every time you use your credit card and either sign an endorsement or slip or enter your PIN, you are generating a credit on the account which is transferred via the credit provider to the store or merchant you are buying your goods from. You create the credit every time, and then they expect you to pay again, claiming that they loan you the money for the item. They are nothing more than money changers. All we should be paying is a small fee for the service. Page 46. Notice of default and demand from hereinafter borrower to, in his private capacity, by agent for dot, hereinafter lender date. Notice of default and demand to cease and desist collection activities prior to validation of purported debt tiers. You have chosen not to respond to my request for adequate assurance. or returned the affidavit enclosed with it, the borrower has become suspicious of your activities and the validity of the agreement. This constitutes timely written notice that the borrower now disputes the entire amount of the alleged loan and declines to pay the purported debt, which, unless I hear from you, I will discharge and cancel in its entirety, without dishonor, on the grounds of breach of contract, false representation, and fraud in the inducement. Failure to answer my previous correspondence tells me that you acknowledge that the borrower funded the alleged loan and the loan agreement was stolen and forged, thus ending any claim you have against him. If you have evidence to validate that your claim does not constitute fraudulent misrepresentation and that the borrower owes this alleged debt, this is a demand that, within 7 days, you provide such validation and supporting evidence to substantiate your claim. Until your claim is validated, you have no authority to instigate any collection activities. This is actual notice that absent the validation of your claim within 7 days, you are prohibited from contacting the borrower at his home or at work. You are further prohibited from contacting his employer, bank, or any third party. Each and every attempted contact will constitute harassment and defamation of character and will subject your institution and any agents in her private capacities who take part in such harassment and defamation to a liability for statutory damages of up to $1,000 and possibly a further liability for legal fees to be paid to any counsel which he may retain. Absent such validation of your claim, you are prohibited from filing any notice of lien and/or levy and are also barred from reporting any derogatory credit information to any credit reporting agency. Verification requires confirmation of correctness, truth, or authenticity by affidavit, oath, or deposition. In accounting, it is the process of substantiating entries in books of account, Black's Law Dictionary, 6th edition. This verification should include, but not be limited to, signing the enclosed affidavit verifying the terms and conditions of the alleged loan and answers to the following list of questions. 1. According to your understanding of the alleged agreement, is the written agreement, by the terms used within it, defining terms of a loan or an exchange of equal value for equal value? 3. If $400 was loaned to the credit card company, would the credit card company's assets and liabilities increase by $400? 3. According to your understanding of the alleged agreement, if the borrower charged $400 to his credit card, does the credit card company receive a $400 asset from the page 47 borrower for free and return the value of this same $400 asset back to the borrower as a loan from the credit card company, and this loan pays for the merchandise he bought using his credit card? 4. According to your understanding of the alleged agreement, does the credit card company charge interest for the use of an asset that the credit card company loaned to the borrower and that existed before he charged the $400 to the credit card? 5. According to your understanding of the alleged agreement, if the borrower uses his credit card to charge $400, according to the credit card company's bookkeeping entries, is the borrower also, at the same time, the lender or creditor to the credit card company in the amount of the $400? 6. Does the credit card company comply with the Reserve Bank's policies and procedures when issuing credit and charging interest to customers of the credit card company when the customer uses the credit card to buy merchandise? 7. Is the credit card company's policy to deny equal protection under the law, money, credit, agreement, or contract to the users of their credit cards? 8. According to the credit card company's bookkeeping entries, if the credit card company paid its debt associated with granting loans, could it pay the debt that the borrower allegedly owes the credit card company? 9. According to the credit card company's policy, did the borrower provide the credit company with an asset and the credit company return that asset back to the same borrower, calling it a loan? 10. According to the credit card company's policy, does the credit card company act like a money changer, receiving an asset from the borrower and returning the value of the asset back to the same borrower and charging as if there were a loan? 11. What are all the bookkeeping entries related to and associated with the credit card transactions for this credit card account? 12. According to the alleged agreement, was the borrower to loan anything to the credit card company? 13. According to the written agreement, was the borrower to give the credit card company anything of value of which caused the credit card company's liabilities to increase by the amount of what the credit card company received? 14. According to your understanding of the alleged agreement, was there to be an exchange of equal value for equal value between the credit card company and the borrower? 15. According to your understanding of the alleged agreement, was there to be an exchange from the borrower? 16. If the credit card company is complying with the Reserve Bank's policies and procedures when issuing credit and charging interest, is the borrower's transaction account credited for the amount borrowed, and is that the matching liability for the amount that is debited to the bank's asset account? 17. If a deposit created through lending is a debt that has to be paid on demand of the depositor, just the same as the debt arising from a customer's deposit of checks of currency in the bank, does that mean that the credit card company owes the borrower for the deposits made in connection with credit card loan transactions? Page 48. 18. When granting loans, if the credit card company's liabilities did not increase, would the bank be in violation of the Reserve Bank's policies and procedures? 19. If the credit card company does not repay a deposit created through lending, would it be in violation of the Reserve Bank's policies and procedures? 20. When a loan is not repaid, is the one who funded the loan damaged? 21. When the credit card company does not repay, upon demand, the deposit made by the borrower, does it show that the policy and intent of the credit card company is to deny equal protection of the agreement, law and credit to the borrower? 22. When the credit card company does not reveal the substance of the transaction in the loan agreement to the borrower, does it show that the policy and intent of the credit card company is to deny full disclosure of the terms of the loan to the borrower? 23. If the substance of the alleged loan agreement does not match the written form of the agreement, does it significantly change the cost and the risk of the written agreement? 24. Is full disclosure of material facts essential to a valid contract in order to have a mutual agreement? 25. In your opinion, is it material or important to know which party is to fund the loan in order to know who is damaged if the loan is not repaid? 26. In your opinion, do you believe the borrower intended to provide the consideration to fund the credit card loan? 27. If the credit card company did not risk any of its assets at any time regarding the written agreement, was this material fact ever disclosed to the borrower? 28. If the credit card company did not risk any of its assets at the time regarding the written agreement, was this material fact ever disclosed to the borrower? 29. According to your understanding of the alleged agreement, if the borrower was to provide the funds for the loans for the credit card account, would the alleged agreement, in your opinion, be unconscionable as defined in Black's Law Dictionary? 30. In your opinion, if a signature is the act of putting one's name at the end of an instrument to attest its validity, Black's Law Dictionary, 6th edition, then could that signature be valid if the instrument itself is an unconscionable bargain or contract? 31. Did the credit card company actually gain title to any debt instrument, credit card slip, that the borrower signed and gave to the merchant for the merchandise received? 32. Do you have personal knowledge that the credit card company provided full disclosure of all the terms of the agreement? 33. Do you have personal knowledge that the credit card company disclosed to the borrower where the money for the loan was coming from? 34. Do you have personal knowledge that the credit card company disclosed that the contract the borrower signed, the promissory note, was going to be converted into a negotiable instrument by the credit card company's accounting books? 35. Do you have personal knowledge that the credit card company disclosed that the borrower's contract or promissory note, money, would be taken and recorded as in page 49? Asset or the credit card company without valuable consideration given to obtain the note? 36. Do you have personal knowledge that the credit card company gave the borrower a deposit slip as a receipt for the money the borrower gave them, just as a bank would normally provide when making a deposit to a bank? 37. You should be aware that sending unsubstantiated demands for payment through the Australian postal system might constitute mail fraud under federal and state law. You may wish to consult with a competent legal advisor before your next communication with me. 38. Your failure to respond on point within 7 days to satisfy this request will be construed as your absolute waiver of any and all claims against the borrower, and your tacit agreement to compensate the borrower for costs including any counsel. For and on behalf of Mr. Job Henry Doe, trademarked by, insert your signature here, John Henry of the Doe family, principal creditor. Unfortunately, there is no way for me to know all of the possible responses or letters that you may or may not receive, so I am unable to write the standard reply for you. However, I will include a couple of common letters and the replies I sent so that you can get the idea. The whole idea of parties or a party comes from the word part, which means a role that an actor plays. Lawyers, police and magistrates act as someone, for someone else, sometimes while wearing costumes. A play also has acts, such as Act 1, Act 2, etc. All these things take place in a court, where in early times a jester would appear to entertain the king. It was all for entertainment, and sometimes the celebration of rape, pillage and plunder of others. From, to non-negotiable final notice. Authorized agent for, principal creditor for all caps, Strawman, trademark hereinafter borrower. In his private capacity, Bay agent for, hereinafter lender. Date, Friday the 6th day of February 2009. ATTN. Your silence and unwillingness to answer any of my previous correspondence or to provide verification of the alleged debt is accepted as tacit agreement and settlement by failure to state a claim upon which relief can be granted. If you have evidence to validate that your claim does not constitute fraudulent misrepresentation and that my client owes this alleged debt, this is a final notice and demand that, within page 50, 7 days, you provide such validation and supporting evidence to substantiate your claim in the form of a written affidavit, signed under penalty of perjury. Until your claim is validated, you have no authority to continue any collection activities, or to make any court order in the matter. This is actual notice that absent the validation of your claim within 7 days, you must cease and desist any and all collection activity and are prohibited from contacting my client at his home or at work. You are further prohibited from contacting his employer, bank, or any third party. Each and every attempted contact will constitute harassment and defamation of character and will subject your agency and or board and any all agents in her private capacities who take part in such harassment and defamation to a liability for statutory damages of up to $1,000, and possibly a further liability for legal fees to be paid to any counsel which he may retain. Further, absent such validation of your claim, you are prohibited from filing any notice of lien and or levy and are also barred from reporting any derogatory credit information to any credit reporting agency. Failure to respond will result in estoppel. Verification requires confirmation of correctness, truth or authenticity by affidavit, oath or deposition. Notice to principal is notice to agent, and notice to agent is notice to principal for and on behalf of Mr. Job Henry Doe, trademarked by, insert your signature here, John Henry of the Doe family, principal creditor, in care of. Address the process step by step. Whenever I start a new claim, I get a fresh folder file, not a manila folder, as things fall out, and attach a custom printed label to it. At the top I write the name of the claim, for example, Cardore and Z Bank Loan, etc. I've reproduced the label here, and once printed out you can use sticky tape or glue to fix it to the front. Page 51 of the folder. This will become your record of action during the time that the claim is open. Each time you send or receive something, make a note of it. You can keep it in a green expansion file within a filing cabinet or archive box, and that way you'll always be able to keep track of which documents were sent and received when, from whom, on what dates. This will become invaluable if you have more than one claim, as the paperwork can quickly start to pile up. I have been asked to make this a beginner's guide for all those new to this process, so those who already have experience can skip this part. Firstly, with all of the documents presented in this book, I have used the name John Henry Doe as an example so that you can see where the all caps version goes, and where your real name goes. Obviously remove all references to John Doe and insert your details. Wherever there is information that you need to fill in, I have either left it blank, or left instructions in brackets for you to follow. Nowhere on your documents should the word Strawman be left on there, as this is where you would insert your all caps person's name. I have purposely not provided any web download, email link, CD or DVD or other source for the editable document files. This is for a reason. If you merely copy and paste info, you will not be doing any work yourself, nor will you be thoroughly reading and retyping, thus getting used to drafting your own letters. Do not attempt any of these processes if you cannot write the documents for yourself, as it is simply not fair to ask people to do all the work for you, and you will not learn anything. Prior to this book being published, I provided some of those documents to people who bought the book, who wanted something to get started on. Unfortunately, I cannot continue to do this, or provide support and backup, as you can imagine with so many orders. I would be on the internet 24 hours a day, and at present I get 15 minutes in the morning and 15 minutes at night. The rest of the time I'm committed to other things. Therefore, I will do my best now to explain the process and hopefully provide answers to frequently asked questions. Let's get started. 1. Gather your documents together. 2. The first package you will be sending out is the Notice of Adequate Assurance for whatever type of claim it is you are doing. Personal loan, credit card or mortgage, plus a blank affidavit, plus any letter of authority if you are using someone as an agent. 3. Pause for a moment to consider if you received something of value, for instance in the case of a car yard, if they gave you a car, and you agreed to pay them for it, and it's a small business. This is different from a bank arranging finance for the car, and monetizing your promissory note, so best to check first the source of the funds. 4. Fill out all the documents correctly, assuming you have retyped them into a Word program such as OpenOffice, free program. Make a copy for your records. Page 52. 5. Double-check them carefully for spelling mistakes, errors, missing information or enjoinders, where you have signed as the Strawman 6. Take the documents to the post office and ask for a registered post envelope and make sure to tell them you want delivery confirmation. 7. Follow the registered post process as documented earlier in this book, and before you seal the envelope, make sure you have written the registered post number on the notice, and filled out all the details on the yellow slip, including the registered post number and a reference such as GE01. 8. Once you're satisfied that you've got everything done, go ahead and post them off. 9. Now you can sit back and wait to receive the delivery confirmation. 10. Place the registered post receipt slip and a copy of the document you posted in the folder, and write the date on the custom sticker you have printed and attached, with a note to yourself such as posted notice of assurance. When you receive the delivery confirmation, write the date in the next line and then received PT delivery confirmation in the action line. 11. Check the delivery confirmation for an office postmark, and write the date of the stamp, if it is not already filled out, in the box that says date delivered next to the signature of the delivery officer. 12. Place the delivery confirmation in the folder. 13. If, after 30 days from the date on the delivery confirmation, you do not get the reply, you can move on to the default notice, which you will fill out and post in the same way, with the second blank affidavit, in case they lost the first one. Cease payments at this point, not before you start the process. 14. You will also need to send a duplicate set of notices, the Notice of Assurance, affidavit, and notice of default to Veda Advantage and Dun & Bradstreet, as they are the main CRAs. 15. This notices them ahead of time, and it looks bad for the bank or credit company if they file any delinquency afterwards. 16. If you do receive a reply within the 30 days, but it does not provide any verification or response to your request, you should consider it as being of no consequence, and reply as such. To whoever, in his/her private capacity, may insert all caps version of their name, agent for, insert lender, CO, insert their address, hereinafter lender from, John Henry of the Doe family, principal creditor for Mr. John H. Doe, hereinafter borrower CO, insert address, postcode and box date, your reference, insert their reference number. Dear whoever is writing to you, I am in receipt of your letter dated, insert date on their letter, received by me today, insert date. Page 53. As you have failed to answer any of my questions, I shall treat your letter as being of no consequence. I shall therefore give you another opportunity to answer the notice of adequate assurance and sign and complete the enclosed affidavit within the original 30-day period as prescribed. I look forward to your response in a timely manner. For and on behalf of Mr. Job Henry Doe, trademarked by, insert your signature here, John Henry of the Doe family, principal creditor. 17. Make sure to record the date you received their letter, or phone call, on the folder, and again follow the process the same as before. Make copies of everything you send out, and place it in the folder. This time they get 7 days from the date that you receive the delivery confirmation, essentially 72 hours plus postage time allowance. Once this time has elapsed and it looks like they are going into silence, dishonor, as a defense against self-incrimination, you can go ahead and issue the final notice. You know the process now. After 7 days, you have won, and it's time to take all the documents down to a notary public to show them, and ask the notary to witness and stamp the default judgment and estoppel notice. 18. Keep the original and get enough certified copies to send out to the lender, as well as copies for Veda and DNB. You can now consider the matter closed by private agreement, and for failure to state a claim upon which relief can be granted. If the lender then fraudulently sells the debt to a debt purchaser such as Trans-Pacific, Repcol Limited, or stupidly hires a lawyer and they contact you hoping to recontract and make you liable for their debt, you would send them a copy of the default judgment, along with the following letter. Note: at no time during this entire process should you discuss the matter or any details whatsoever over the phone. See section on redraft date of receipt, date of reply/postage. 2. Notice of conditional acceptance. Your offer to accept liability for your debts has been conditionally accepted for value upon proof of claim that you can provide a signed contract between your company and myself that creates such obligation, and proof that this matter has not already been settled in the private. For and on behalf of Mr. Job Henry Doe, by insert your signature here. Page 54. John Henry of the Doe family, principal creditor, private default judgment having the same effect as res judicata and stare decisis state of SS. Verification dated, petitioner, respondent, judgment based on the attached notice of adequate assurance, default notice and final notice in support of private judgment and decision, and the evidence attached to said notices, all of which has been presented to me. It is the judgment and decision that 1. Petitioner is the injured party in this matter. 2. Petitioner properly noticed respondent. 3. Respondent failed to answer or otherwise respond, and therefore stands in agreement with petitioner. Decision. Therefore, it is the decision that the parties have reached the following agreement: A. That there is no documentation verifying that the respondent has any claim in the matter. B. The matter is resolved. Decision dated this day of 2009, state of SS. Acknowledgement for the purpose of verification of signatures and for public notice. I, the undersigned notary public, being commissioned in the state noted above, do declare on the day of 2009, the ones known to me to be, or who proved to me to be the parties who executed this document before me. Notary Public Note: this judgment document has not been trialed or perfected yet. Birth certificates below is an example of taking control of the Strawman from birth. The trouble is that many of us cannot afford private hospitals, so we're forced to go public. If it is indeed the voluntary registration of the child that creates the fictitious legal person, then a document like this is not going to make the state very happy. Page 55. Queen, Crown and Commonwealth. So just what is this all-pervading sovereign entity, and why does it hold the greatest seat of power in the world today? For those of you who are unaware, you should know that the British flag, the Union Jack, is in reality the Union of Jacob, and in fact 3 flags combined. The British, Brit meaning covenant and Ish meaning land, are the only true Jews. Originally there were 12 tribes of Israel, well 13 to be precise, including the tribe of Dan that later moved to Europe and became the Danish in Denmark. The Union Jack symbolizing God's covenant with Israel. Scotland, St. Andrew, the Abrahamic covenant with his hands crossed. Jacob passed on the blessings of national greatness to Ephraim and Manasseh. This was not a blood covenant, hence the blue background. Genesis 48. Ireland, St. Patrick, the Mosaic or Old Covenant, a blood covenant, broken by Israel, symbolized by the red cross broken in the center. The covenant of Moses broken by Israel showed need of a savior. Jeremiah 31, 31-34. Page 56. England, St. George, the new covenant of redemption, the victory of Christ over Satan's evil kingdom, St. George over the dragon, established by the new covenant. The blood of Christ shed on the cross shown by the red cross of St. George. Redemption of Israel and personal salvation now possible through the crucifixion of the Savior. Hebrews 13, 20-21. National flag of the Anglo-Saxon Celtic people identifying Israel, Jacob today. Note the cross of St. George predominating. The new covenant brought blotting out of transgressions committed under Old Covenant, and made possible fulfillment of national promises given under 2 covenants. Jesus Christ, Redeemer of Israel, and Savior of the world. Luke 1, 68, John L, 29. The British royal family is a mix of Jewish and German bloodlines, which extends all the way back to Israel. If you can get an original full-size chart called God's Great Week, you can see how the lineage goes all the way back to Judah. God's Great Week, the divine plan of the ages, revealing the birthright and destiny of the Anglo-Saxon race. The coronation stone that sits under the throne in Westminster Abbey, where the kings and queens are crowned, is the stone of Jacob that was brought from Israel, via the Rock of Gibraltar, to Ireland, then Scotland and finally to London. Now with that in mind, and what we have been discussing in regard to vessels and admiralty law, consider this piece of text I came across by chance. A vessel is a container, utensil, dish, article or thing. The Hebrew word for a vessel, among others, is receptacle, a container or a space for placing or storing things. In short, a vessel is made for the sole aim of containing or storing things. Every vessel is created by the intent of the Maker. The Lord relates the whole tribe of Israel as vessel and himself as the potter. From what I've been able to gather, the queen has no more power, but instead is a figurehead, a symbol and a private company, with power transferred to the Commonwealth, whatever entity that is. And now in joining the European Union, power again has been transferred. There is much debate about what actual power this crown has here in Australia, as we are supposed to be a sovereign nation, but the police, courts and other officials still swear an oath to the Queen. If all of the laws and paperwork are copyright to the Crown, a legal fiction, then it makes sense that if we were to become a republic, then we would need to create all our own statutes, acts and documents, or perhaps license them from the Crown. The Union of Jacob, page 57. Page 58. The City of London, Corp., and the District of Columbia USA Corp. Are both 10-square-mile jurisdictions of private corporations that appear to be joined at the hip by bloodlines from these tribes. The Statue of Liberty, Sam Irmies, Columbia, the triple goddess, Tristaran and Amazon queen, is really the Babylonian goddess of war. You can see her personified in companies such as Amazon, created by a Phi Beta Kappa member, and as the logo for Columbia TriStar, and she appears again in her full glory on the new Amero currency that is to be soon ushered in to replace the failing US dollar that represented the currency of the United States of America Corporation. Now with the Union of North America, Mexico, USA and Canada, all joined together as a superstate, the powers that be, the ones that control the banks and corporations only need to crash the US dollar to be able to enslave the population and steal their wealth. People will soon come to understand, as they did in Germany in the 1930s, that paper money has no value, and now with everything computerized, the ones and zeros on computers are also completely worthless. Digital information does not really exist anywhere, another fiction, and if you've ever lost a hard drive, you'll know what I mean. Photos, documents, files and programs are all ones and zeros. Now this may be completely new to you as you read this, so I suggest that you start researching this for yourself, as this information will not be found in mainstream media or television or newspapers, and the ones that control the world, control the media. Here is a look at the new Amero currency that is being prepared, compared with an old coin showing samurai armies. The global economy is finished. It cannot survive because it is based on fiction, the creation of paper money backed by nothing, and loans that are created out of thin air, is a system of banking that has come to an end. Here is Liberty, samurai armies, holding her torch, illuminated ones, with the world tossed aside, and also holding her iconic spear. She was known as the Spear Shaker. Hidden behind her is a pyramid. Under her legs and on the front of the coin is the Nazi eagle showing the Union of North America. Do you see any common elements in these all images? Page 59. Are all these unions a return to the Union of Jacob? Even the Vatican has the Union Jack in its keyhole courtyard with an Egyptian obelisk at its center. The other two obelisks are in London and Washington, D.C., District of Columbia. Now, everyone has heard about the Third Reich, but what about the First and Second? Reich means empire, and the First Reich was the Holy Roman Empire. The Second Reich was the Bavarian Illuminati. The Third Empire is still going, as all the top German scientists and leaders were moved to America, spawning NASA and the CIA. New York is also known as the Empire State. But surely the Queen and Commonwealth are not concerned with the cultic symbolism and ancient Egyptian mysteries. Or are they? How about the Pope? Surely he's not in on all of this, is he? We all know about the Egyptian, Masonic symbolism in Washington, in the layout of the roads and monuments, and you might think that Australia is a long way away from all of that occult mysticism and secret symbols. So just to put your mind at rest, let's take a look at Canberra and see if there might be any pyramids, all-seeing eyes, or Illuminati influence, that will tell you if this is all just a conspiracy theory or coincidence. Compare this with the MI5 logo and note the illuminated apex of the pyramid on the base corners. This book is not really about the NWO, but one cannot explore the hidden world without constantly bumping into all these skeletons hiding in the closet. Page 60. Let's move on to the contractual relationships we have with these legal fictions and see why and how they are able to have such far-reaching control over our everyday lives, including requirement to ask permission to do just about everything, including making alterations to our home. Citizenship and marriage licenses. There is a difference between a citizen and a free man or woman, and between marriage in a church or other ceremony and marrying the state using a celebrant or registry. On the front of the citizenship certificate is listed the name of the citizen or person, Strawman applicant, either in all caps or like this, Job Henry Doe. You then swear an oath, the proof of which is shown here on the back, and your person's particulars are recorded, so that your body can be identified with the fiction. A legal fiction, of course, has no eyes or hair color, but the enjointer fuses the two of you together, and you are now a person or citizen, and subject to the laws of the Commonwealth. I once read that for a British subject living in Australia, the laws of the Commonwealth of Australia do not apply, unless they have citizenship. So you can see that it is a contract by consent, albeit not a valid one, as there is not full disclosure, but essentially allowing the government and state control of your person. From the Australian Citizenship Amendment Act 1993, page 61. Australian citizenship represents formal membership of the community of the Commonwealth of Australia, and Australian citizenship is a common bond, involving reciprocal rights and obligations, uniting all Australians, while respecting their diversity, and persons granted Australian citizenship enjoy these rights and undertake to accept these obligations by pledging loyalty to Australia and its people, and by sharing their democratic beliefs, and by respecting their rights and liberties, and by upholding and obeying the laws of Australia. Citizenship in Australia has a complex and confusing history. At Federation, in 1901 no legal category of Australian citizenship existed. British subject remained the sole civic status. Since the delegates of the Australasian Federal Convention of 1897-98 faltered over the issue of citizenship, the Australian Constitution provided neither a definition of citizenship, nor a power over it. The term citizen was not employed in British law, which spoke only of subjects at that time, although the former term was frequently used in political discussion to refer to the members of the colonies and the mooted Federation. The convention wished to preserve the British nationality and British subject status already existing in the colonies, since both politicians and public identified themselves and the state they were creating as British. Several notable liberals argued, as much from nationalist enthusiasm as legal need, that a definition of citizenship, or a power over it, should be included in the Constitution to identify British subjects resident in Australia and to allow future parliaments to deal with circumstances which the delegates could not yet envisage. However, the proposal failed when agreement could not be reached on a meaning for an Australian citizenship supplementary to the status of British subject, and the issue became confused over the coexistence of state and federal citizenships. When the matter was revisited during a proposal for a safeguard of individual rights which eventually became, in much reduced form, Section 117 of the Constitution, debate again floundered in confusion over interpretation of the term citizen. Its Republican connotations also figured in the reticence of delegates to give it legal meaning, because it could be construed as a departure from British forms of government. Eventually, the term citizen was avoided in the Constitution and reference made only to the people of the Commonwealth. In September 1945, Arthur Calwell, the Minister for Immigration 1945-49, proposed to Cabinet that Australian nationality be defined in law. Canada also announced that month that it intended to introduce legislation providing for a separate Canadian citizenship. Page 62. For Calwell, an Australian nationality he equated nationality with citizenship would facilitate immigration and deportation, the issue of passports, and the representation of Australians abroad. He proposed a definition of an Australian national as 1. A person born in Australia who has not acquired another nationality, 2. A British subject not born in Australia who was not a prohibited immigrant at his time of entry and has resided in Australia for 5 years, 3. A person naturalised in Australia who has residence of 5 years, 4. The wife of an Australian national who is herself a British subject resident in Australia, 5. Children born outside Australia whose fathers at time of birth were Australian nationals. The Nationality and Citizenship Act 1948 formalized the existing de facto categories of citizenship. The Act created a legal status of Australian citizenship devoid of any new substance, which meant no more than the de facto administrative concept that preceded it. Australian citizens were still British subjects, and were only to be distinguished from the general category of British subjects, and Irish citizens, by rights of movement, permanent residence, and departure and return. Alien was given formal definition as a person who is not a British subject, an Irish citizen or a protected person, The foreigner remained defined against British subject status and not against Australian citizenship. The marriage license is a contract between the parties and the state. The state is the principal party in that contract. The husband and wife are secondary or inferior parties. Page 63. In the traditional sense, a marriage is a covenant between the husband and wife and God. But in the contract with the state, reference to God is a dotted line, and not officially included in the contract at all. If the husband and wife wish to include God as a party in their marriage, that is a dotted line they will have to add in their own minds. The state's marriage license is strictly secular. What is meant by the relationship to God being a dotted line meant that the state regards any mention of God as irrelevant, even meaningless. In a religious context, marriage was a covenant between the husband and wife and God, with husband and wife joined as one. This is not the case in the realm of the state's marriage license contract. The state is the principal or dominant party. The husband and wife are merely contractually joined as business partners, not in any religious union. They may even be considered connected to each other by another dotted line. If you would like to read a legal treatise on marriage, Principles of Community Property, by William de Funiac, explains that community property law descends from Roman civil law through the Spanish codes, 600 AD. In civil law, the marriage is considered to be a profit-making venture, even though it may never actually produce a profit in operation, and as the wife goes out to the local market to purchase foodstuffs and other supplies for the marriage household, she is replenishing the stocks of the business. Moreover, as children come into the marriage household, the business venture is considered to have expanded. Under contract law, every valid contract must have equal consideration. The state offers consideration in the form of the actual license itself, the piece of paper, the certificate of marriage. The other part of consideration by the state is the privilege to be regulated by statute. This privilege to be regulated by statute includes all related statutes, and all court cases as they are ruled upon by the courts, and all statutes and regulations in the years following the commencement of the marriage. However, a valid contract must also have full disclosure, or it becomes null and void by way of misrepresentation. Failure by the state to make full disclosure of the terms and conditions means that technically there is no contract. Another way to look at the marriage license contract with the state is as a contract of adhesion. Consideration on the part of the husband and wife is the actual fee paid and the implied agreement to be subject to the state's statutes, rules, and regulations in all court cases ruled on related to marriage law, family law, children, and property. This contractual consideration by the bride and groom places them in a definite and defined by law position inferior and subject to the state. Page 64. It is very important to realize that children born to the marriage are considered by law as the fruit of the contract, meaning the children primarily belong to the state, even though the law never comes out and says it. There have been Supreme Court cases which state that parents have no property right in their children, and have custody of their children during good behavior at the sufferance of the state. This means that parents may raise their children and maintain custody of their children as long as they don't offend the state, but if they in some manner displease the state can step in at any time and exercise its superior status and take custody and control of its children. Technically, the marriage license is a business license allowing the husband and wife, in the name of the marriage, to enter into contracts with third parties and contract mortgages and debts. They can get car loans, home mortgages, and installment debts in the name of the marriage because it is not only an enterprise, but it is looked upon by the state as a privileged business enterprise as well as a for-profit business enterprise. The marriage contract acquires property throughout its existence and over time, it is hoped, increases in value. If sometime later, the marriage fails, and a divorce results, the contract continues in existence. The divorce is merely a contractual dissolution or amendment of the terms and conditions of the contract. Jurisdiction of the state over the marriage, over the husband and wife, now separated, continues over all aspects of the marriage, over marital property and over children brought into the marriage. That is why family law courts calls divorce dissolution of the marriage, because the contract continues in operation but in amended or modified form. The marriage license contract is one of the strongest, most binding contractual relationships the state has on people. I believe this is why the government believes it can do whatever it likes, such as the fluoridation of the water supply and introduction of wastewater into the food chain. The death of the Strawman. Take a look in the local paper and you will find a public notices section, where they list births, deaths and marriages. These are all the listings of the comings and goings, registrations and deregistrations of the person fictions. The following clipping shows the closure of the account, and the public notice of the death of the person. Identification. This ID card was created several years ago and needs rewording to reflect the latest information and layout as per other documents in this book, but serves as an example for those who have programs such as Photoshop or similar text and image editing software and can use them. There is no real step-by-step method to becoming a free man or woman, but what I can suggest is research and learn to take control of your Strawman by correcting your enjoinders and past contractual obligations as best you can. Start with something simple such as your library card, then move on to your bank card. Driver's license, you'll need to get a new one issued to sign properly, your passport, and then from now page 65 on, remember how to sign properly, on behalf of the Strawman, as the principal creditor, and not as the surety, liability for it. If anyone asks you why, tell them that you have a trademark that looks like your name, so if they can't print your real name, they need to add the letters trademark to it. We will control the goyim, people, with numbers and paper. The protocols of the learned elders of Zion. Taxation and the auto. In this section I will attempt to present as much research as I have been able to discover about the auto and tax system, but must advise that this is not to be construed as legal advice. What I will be focusing on is the fraud and illusion as well as the propaganda associated with the collection of tax from the person. I'm going to start with one of the most misunderstood terms that the auto used to fraudulently make you liable for tax, and that is the label of sole trader. From the Corporations Law 1989, sole trader means a person who is a member or organization of a securities exchange. Note the duality of it with the term sole trader and you have a more accurate description. Member organization means A. In relation to a securities exchange or stock exchange. Securities exchange means A. In a provision, other than a provision of this chapter or chapter 6 or 7, for the purposes of which a regulation is enforced, defining that expression a securities exchange as defined by that regulation, or in chapter 6, I, the exchange, page 66. If a sole trader is an individual, then the definition of an individual is a person who is a member or organization of a securities exchange. Corporations Law 1989. Since a living soul within the body of a man or woman is not an organization or a legal fiction, then in this context, a person must be a corporation. Since a person in this context means a corporation, then an individual in this context is also a corporation. Income Tax Act 1986 Section 17 Levy of Income Tax 17(1), levied on taxable incomes of certain persons subject to this act. Income tax at the rates declared by the Parliament is levied, and shall be paid, for the financial year that commenced on July 1, 1965 and for each succeeding financial year, upon the taxable income derived during the year of income by any person, whether a resident or a non-resident. The term person includes an individual, a company and any other body of persons. Taxation tax. A charge, especially a pecuniary burden which is imposed by authority. Specifically, a charge or burden laid upon persons on property for the support of a government. 2. Australian Stock Exchange, Adelaide, Limited. 3. Australian Stock Exchange, Brisbane, Limited. 4. Australian Stock Exchange, Hobart, Limited. V. Australian Stock Exchange, Melbourne, Limited. 5. Australian Stock Exchange, Perth, Limited. 7. Australian Stock Exchange, Sydney, Limited, auto application forms. The application form entitled ABN Registration for Individuals, Sole Traders, is available at most auto offices and is misleading and fraudulent for the following reasons. 1. The title makes a formal definition of an individual as a sole trader by the addition of brackets, thereby informing anyone who considers themselves an individual that they are to be classified as a sole trader by the Auto and the Commonwealth of Australia. Page 67. Levy. The act of levying or collecting by authority, as the levy of troops, taxes, etc. The following document and report was entrusted to me for research purposes, and is reproduced here for your interest. Keep in mind what I said before about citizenship and hidden contracts. This demonstrates, however, that there is much that we are not told about the contractual obligations and voluntary enslavement that goes on all the time. Auto Questionnaire. This questionnaire has been compiled to gain a better knowledge of the relationship, if any, between the Australian Taxation Office, hereafter Auto, its agents, representatives, employees and the undersigned, hereafter author. The author claims advice and assistance is offered by the Auto as follows. Page 08 of the Taxpayers' Charter in detail. Section C states, you're entitled to receive professional service and assistance from us, and we provide advice, information and assistance to help you understand and meet your tax obligations and make you aware of your rights and entitlements. Usually this is free and includes spoken and written advice. Page 12 of the Taxpayers' Charter in detail. Section H states, you can expect us to give you advice and information you can rely on. Disclaimer: at no time does the author admit to, consent, or in any other way imply that there is a relationship with or obligation to the Auto as a taxpayer or person or otherwise by asking these questions. Furthermore, the author shall not be a party to any agreement, express, written, oral, implied, or otherwise if during the course of the visit to the Auto he is asked to state his name or by any other act, and he shall endeavor to make this known to anyone who asks for his name. The author does not consent to the voice recording, capture of photographic likeness or video recording of his person at any time. Any and all questions asked by the author that appear on this questionnaire will be deemed to have been asked, if there appears a circle or tick around or next to the appropriate answer. In the event that any Auto agent, representative or employee will not answer these questions or upon answering refuses to verify their statements as true and correct to the best of their knowledge by their signature, it may be assumed that the person is either not qualified to provide that information or that the information given by that person is invalid or is in some way misleading, fraudulent or incorrect. Acceptance your name. As per page 08 section C Taxpayers' Charter date. Questions. Question 1. Are you willing to answer the following 20 questions as per the offer in Section C, page 08 of the Taxpayers' Charter in detail, which relate to tax obligations? Please circle yes, no. Page 68. Question 2. What is your official position at the Auto? A. Question 3. Are you the person of highest authority in this branch office? Yes, no. If no, please state the person of highest authority. Question 4. In order to clarify your position, are you an employee of the Auto or are you personally employed by the Commissioner or Deputy Commissioner of Taxation? A. Question 5. Have you read or are you aware of the statements made by the Honorable J. Hill in the Federal Court case Deputy Commissioner of Taxation versus Levick? Yes, no. Question 6. Is the Auto responsible for the collection of a debt payable to the Commonwealth? Yes, no. Question 7. Can the Auto sue a living soul within the body of a man or woman that does wish to act as surety for an alleged debt as above mentioned? Yes, no. Other, please state. Question 8. In regard to the Auto form application to cancel registration, there are a number of confusing and misleading questions. Could you please clarify the following? A. What is your definition of an entity? B. Is a living soul within the body of a man or woman an entity? Yes, no. Question 9. In the above-mentioned form, it states that an entity refers to the sole trader, partnership, company, trust, superannuation fund or other type of organization that is applying to cancel its registration. What is the exact definition of a sole trader? A. Question 10. Is a living soul within the body of a man or woman a member or organization of a securities exchange? Yes, no. Question 10. Who does the ABN actually represent? That is, whose ABN is it? A. The entity. B. The tax agent, partner or trustee. Copyright the living soul within the body of a man or woman that is filling out the form. D. All of the above. E. Other. Please explain. Question 10. Is the ABN transferable? Yes, no. Question 11. Is an entity transparent for taxation purposes? Yes, no. Question 12. Is there disclosure on the above-mentioned form and all other auto documents? Yes, no. Page 69. Question 13. Where can that information be easily found or accessible to the public? A. Question 14. Is a person a living soul within the body of a man or woman? Yes, no. If yes, please indicate the law or act that says this. Question 15. Is a person's in all capital letters a corporation or other organization? Yes, no. Question 16. Have you read and do you understand the Income Tax Act 1986? Yes, no. Other. Please explain. Question 17. Have you read and do you understand the Corporations Act 2001? Yes, no. Other. Please explain. Question 18. Have you read and do you understand how to understand an Act of Parliament 80th edition by D.J. Gifford and Kenneth H. Gifford? Yes, no. Question 19. What is a taxpayer? A. Question 20. In consideration of the above questions, is it true then to say that the auto can only levy taxes and gain authority over a living soul within the body of a man or woman, by their voluntary or assumed agreement, and by the transformation of that person into an entity known as a person or taxpayer? Yes, no. Acknowledgement. I acknowledge that this questionnaire has been completed voluntarily, and has been answered to the best of my knowledge and ability. I believe these answers to be true and correct, and accept full responsibility for any information that is in any way false, misleading or fraudulent under oath of office, if any. Signed. Author name. Name. Principal creditor for, insert all caps, Strawman name, all rights reserved. The author states that until such time as undeniable proof is provided to him as to the existence of a relationships between the author as a living life force within the body of a man and the auto, the author must assume that there is none. The author, having taken as much care as possible to investigate this matter, cannot therefore be held responsible for any claim of tax avoidance, or otherwise, as he has taken reasonable steps to establish the facts. The author claims that in the event that no relationship can be proven to exist between the auto and the author, any prior relationship must therefore have been fraudulent, and is void by way of misrepresentation and coercion, and all signatures that may have been provided are hereby rescinded. Page 70. Conclusion. It is the author's conclusion and suggestion that as the auto is not recognized by the federal court, and as it is common ground that there was no notice of gazettal published which related to any change of name of a department giving rise to the Australian Taxation Office, and as the auto currently promotes and supplies documentation which is of a fraudulent and misleading nature, then the author suggests the immediate closure of all auto offices, pending further review. Supporting evidence and research. The following information is provided in relation to and support of the questionnaire and report, and has been personally conducted by the author. The definitions were found in Australian government and Commonwealth documentation, including acts and laws, and further clarification was sought as per the advice in the book How to Understand an Act of Parliament 80th edition by D.J. Gifford and Kenneth H. Gifford. Chapter 2a reads, in finding the right meaning to give to an Act of Parliament, the reader must give close attention to the meaning of each word that is used. This will often involve turning to the judicial dictionaries or to the standard dictionaries such as the Oxford English Dictionary to find the meanings given to individual words in the section. The following common dictionaries were referenced as per that advice: Oxford Australian Words and Their Origins 1989, the Oxford English Dictionary, the Collins Australian Dictionary 5th edition, Australian Oxford Dictionary 2nd edition, Chambers Dictionary 9th edition, the Macquarie Dictionary 3rd edition, Wikipedia Online Dictionary. The auto provides advice and collects information relating to obligations under the Income Tax Act 1986. It promotes and supports legislation and laws made by the government and Commonwealth of Australia. The Taxpayers' Charter in detail outlines the relationship we seek with the community, and the more you know and understand these factors, the more confident you'll be in dealing with us. Understanding: the author hereby states that he does not understand under, in, or to a position below or beneath something, in or into a condition of subjection, subordination, or unconsciousness. Standing: a position from which one may assert or enforce legal rights and duties. Contract law: for a valid contract to be enforced, there are a number of basic rules which must be followed. A contract is any legally enforceable promise or set of promises made by one party to another and, as such, reflects the policies represented by freedom of contract. In the civil law, contracts are considered to be part of the general law of obligations. Page 71. Basic common law contract law addresses four sets of issues. 1. When and how is a contract formed? 2. When may a party escape obligations of a contract, such as a contract formed under duress or because of a misrepresentation? 3. What is the meaning and effect to be given to the terms of a contract? 4. What is the remedy to be given for breach of contract? Contract formation: generally, formation of a contract requires a bargain in which there is a manifestation of mutual assent to the exchange and a consideration. See also consideration under English law. Escape from contract: a party may in some cases escape obligations established by a contract for one of the following reasons: mutual or unilateral mistake as to a basic assumption upon which the contract was made, misrepresentation of facts inducing one of the parties to enter the contract, duress inducing one of the parties to enter the contract, lack of capacity to contract, such as infancy, influence of drugs, alcohol or mental illness, unconscionability, violation of a public policy, absence of a writing evidencing formation of the contract if the statute of frauds requires such a writing, performance of the contract becomes impossible or extremely difficult or costly by virtue of events occurring after the contract is formed, the principal purpose of the contract is substantially frustrated by virtue of events occurring after the contract is formed. In some situations, a collateral contract may exist. Meaning and effect of contract terms: many contract disputes involve a disagreement between the parties about what terms in the contract require each party to do or refrain from doing. Hence, many rules of contract law pertain to interpretation of terms of a contract that are vague or ambiguous. The parole evidence rule limits what things can be taken into account when trying to interpret the contract. Privity: in general, only parties to a contract may sue for the breach of contract. Validity of contracts: for a contract to be valid, it must meet the following criteria: mutual agreement, see main article. Offer and acceptance: there must be an express or implied agreement. The essential requirement is that there be evidence that the parties had each from an objective perspective engaged in conduct manifesting their assent, and a contract will be formed when the parties have met such a requirement. For a contract based on offer and acceptance to be enforced, the terms must be capable of determination. Page 72. In a way that it is clear that the parties' assent was given to the same terms. The terms, like the manifestation of assent itself, are determined objectively. Consideration: there must be consideration, see also consideration under English law, given by all the parties, meaning that every party is conferring a benefit on the other party or himself sustaining a recognizable detriment, such as a reduction of the party's alternative courses of action where the party would otherwise be free to act with respect to the subject matter without any limitation. Competent, adult, sui juris, Parties. Both parties must have the capacity to understand the terms of the contract they are entering into, and the consequences of the promises they make. For example, animals, minor children, and mentally disabled individuals do not have the capacity to form a contract, and any contracts with them will be considered void or voidable. Although corporations are technically legal fictions, they are considered persons under the law, and thus fit to engage in contracts. For adults, most jurisdictions have statutes declaring that the capacity of parties to a contract is presumed, so that one resisting enforcement of a contract on grounds that a party lacked the capacity to be bound bears the burden of persuasion on the issue of capacity. Proper subject matter. The contract must have a lawful purpose. A contract to commit murder in exchange for money will not be enforced by the courts. It is void ab initio, meaning from the beginning. Mutual right to remedy. Both parties must have an equal right to remedy upon breach of the terms by the other party. Mutual obligation to perform. Both parties must have some obligation to fulfill to the other. This could be distinct from consideration, which may be an initial inducement into the contract. Primary liability. Ordinarily, the liability of a maker or acceptor is primati. Black's Law Dictionary. The maker of a check has primary liability. Payer. So when a policy enforcer writes you a ticket, he is the maker or drawer. The payee is the government or state, which means that you are the bank. The maker owes the debt, but only the bank can refuse to pay. The banker's handbook states that no bank is allowed to dishonor an instrument, therefore you must do a conditional acceptance. Page 73. Fines and infringement notices. Human equals human, the color of a man. All laws are colorable, in that they can be interpreted in different ways. Speeding means you are not blocking traffic, so the presumption is that you are going over the limit. You can plead guilty to the facts, but not to the presumptions. Hearsay is not admissible in court. You will notice on all tickets that it's an allegation, which is not fact, unless you are silent, agreement, or argue. Enter the controversy. On the front of the infringement notice, there is usually a statement such as this: do not pay this ticket if you are submitting a statutory declaration. Of course, what they want you to do is argue, and so they include an already filled out statutory declaration for you to sign, which is all about argument or controversy. It's a trap to get you into the center. It doesn't specify what kind of statutory declaration, so you can pick up a blank one at your local post office and fill it out in the form of a conditional acceptance or negative averment. It's an offer, so why not accept it? A negative averment looks like this: I have not seen, nor am I in possession of any evidence that suggests that John Henry Doe and John H. Doe are the same person, and believe that none exists. I have not seen, nor am I in possession of any evidence that shows that a legal fiction can physically do anything, and believe that none exists. I have not seen, nor am I in possession of any proof that there is any lawful money in circulation, backed by anything of value with which to pay, and believe that none exists. I have not seen, nor am I in possession of any information that shows that the maker of an instrument does not have primary liability, and believe that none exists. We have tried this method, and it did work. However, after 3 months, the person received a notice, perhaps automated, saying that 3 points had been deducted. At least there was no enforcement or further attempt to collect the $360 fine. That notice could be accepted for value also upon proof of claim that there is a valid judgment in the matter. www.courts.ca.gov.au. Here's a nasty notice I got a few years ago. Scary, isn't it? It's meant to coerce you into page 74. Compliance using fear and threats. Using the methods contained in this book, I successfully settled the matter in the private, through the return of their presents to the registrar within 72 hours. I have done this with summons, presentments, court notices and several other instruments, so I know it works. Out of interest, I just did my credit file check, and there was nothing in there. The coming global monetary collapse research indicates that there is something sinister going on behind the scenes right now that we are not being told about in relation to the financial collapse which is being carefully orchestrated by the world banking elite. Soon there might not be any value to what you think is money, and the only real things of value are silver and gold. 2 years ago I went to buy some gold. It was $800 an ounce, up from $400 an ounce a couple of years before. Now it has jumped to $1,600 an ounce and is still rising. Survival tips: make a list of all the expendables that you would ordinarily use every day, and stock enough food and water to last you for at least 6 months. Those with the means to do so, please consider the following recommendations. I would suggest mid to late 2009 that a collapse may occur, so be prepared. 1. Money. Buy as much gold as you can afford. For example, on eBay you can buy a troy ounce .999 pure for about $1,500, $1,600 at the moment. If you have the means, buy a safe and hide it. 2. Power. Buy one or more power inverters for changing 12V into 240V, ideal for running a small fridge backup or other electrical items, available for as little as $50 for 500 watt. If you have the means, buy a portable generator. Buy as many candles and matches as you can. Solar panels hooked up to a battery with an inverter gives you cold storage in light or heat power. 9. Seeds. Get as many unmodified, non-GM seeds as possible, focusing on things that grow easily, quickly, and check the expiry date to be at least 2011. Plant some vegetables now and learn to grow them. 4. Water. If you don't have enough spare filtered drinking water to last 6 months, then it's time to stock up. If you have the means, please consider buying one of these for your home. http://www.watermaster.c/com/main/product/c200do watermaker.htm, or at least buy a rainwater tank and fill it. 5. Food. Canned food, dried foods, pasta, rice, powdered milk. Buy carb soda, as much as you can stock that has at least 12 months or more shelf life, and put it away in a cool, dark place. Start growing your own food. Vitamins. Colloidal silver. Olive leaf extract. Locate your nearest farmer's market. 6. If you have the means, get hold of a food saver vacuum sealer. 7. Expendables. Toilet paper, shavers, soap, washing powder, etc. Page 75. 8. Fuel. BBQ bricks, fire starters, kerosene, petrol spare. Communications. Do you have a list of all your family and friends' addresses and contact numbers written down? Most rely on storing data digitally these days, but if you lose it, it's all gone. Backup anyway, but make sure you have hard copies of all important data. Print out any important info and archive it. If you have the means, buy a shortwave radio or CB radio. 7. Clothing. Make sure you have practical clothing for winter and summer, including strong walking or hiking shoes. 8. Get off your seat, turn off the TV, and do something about this now. Time is almost up. If you haven't watched the Doco Firewall yet, please do so. http://newsbrowser.org/firewall/index.html. This is by no means an exhaustive list. Buy and SAS Survival Manual for more info. Suggested reading: How I Clobbered Every Bureaucratic Cash Confiscatory Agency Known to Man by Mary Croft. Cracking the Code by D. Answer and Better Books, a practical course in miracles. The Secret Banker's Handbook by Tom Schauf. Australia Concealed Colony by ICENR. Judges Bench Book. Notary Public Manual. Governor's Reference Manual for Notaries. Australian Constitution, Citizenship Act, Police Powers Act, Motor Vehicle Act, Corporations Law, Federal Magistrates Court Rules 2001, Consumer Credit Code, Privacy Act, Instruments Act, Bills of Exchange Act, Governor General Act, and as many other relevant acts as you wish to explore that pertain to persons. Lost at Sea: International Law and Maritime Process. The Master Key System by Charles F. Haanel. Think and Grow Rich by Napoleon Hill. Secrets of Rapid Manifestation by Dr. Robert Anthony Morals and Dogma by Albert Pike. The Secret Teachings of All Ages by Manly P. Hall. Bursting Bubbles of Government Deception by Rob Minor. The Anti-Government Movement Handbook. Not what you think. This is propaganda by the system against common law use, and the admission that Waco was a terrible display of force by the government, essentially destroying anyone who proclaims themselves to be free. This is by no means an exhaustive list, just a few things to start off with, otherwise you'll get overwhelmed, and it's important to absorb and comprehend one thing, then read many things and not get the point. Documentary list: Firewall, The Illuminati, Chris Everett, page 76. Endgame: Alex Jones, 0-911. Loose Change: Orwell rolls in his grave. The Horizon Project: America, Freedom to Fascism. Aaron Russo, The Harmonic Code. Bruce Cathy, Ring of Power. The Magnificent Deception. Rob Minard, Fabled Enemies. Welcome to the Evolution. Ian's Long-Old Secret Space. Chris Everett, The Order of Death. Alex Jones, page 77. End note: thank you for supporting the creation of this book, and allowing the universe to express itself through me. I believe that in the past much has been done to try and stop people from speaking out for themselves, silencing them in whatever way the system likes, and certainly there have been many cases of brutal force by the police and military against peaceful, sometimes innocent men, women and children who stand up for and claim their rights. This is a game. We have not yet been given the rulebook or a guide, so we are having to write it as we go along, making mistakes and correcting them. Now, with the global consciousness awakening at a very deep and profound level, and with new information coming to light every day, the system is failing under the weight and pressure to come clean on all that has fraudulently and misleadingly been done and continues to be done on a daily basis. I hope that this information is of use to you, and that you will consider my next book eyes only when I can find some more free time to compile it from the thousands of documents, research papers, letters, acts, and images I've collected over the past 20 years. This book was a brief look into another world that most didn't realize was there. You now know far more than the governments, banks and corporations want you to know, but still far less than you should. There is a great scene in Smokey and the Bandit 2, where Burt Reynolds is being chased by hundreds of police cars. When the snowman appears up ahead in his truck to help, it looks like just one truck. Then out from behind him comes another 2 trucks, and another 2, until there's a mile-wide line of trucks, ready to take on the pirates. It's a scene that always gives me hope that the growing number of awakened souls will eventually stop this tyrannical empire. Remember ... the Force will be with you. Always. Thomas Anderson T. Legal Fiction, all rights reserved. Copyright 2009, except for reproductions of Crown material for research purposes. Page 78. This book is available for purchase from http://anglo-saxonisrael.com/site/Dallas Conspiracy. Page 79. The New Christian Crusade Church calling the people of Britain. At last the Bible makes sense. At last we know its meaning. It's the book of the race, for out of Zion shall go forth the law, and the word of the Lord from Jerusalem. Isaiah 2-3.